All right. Good morning, ladies and gentlemen. We are about to begin with our state all-purpose calendar with Fulton County. It's going to be a. All right. Good morning, everyone. This is going to be a list of criminal misdemeanor cases in which individuals have already been accused and bonds have already been provided in these cases. We are going to be addressing these cases with regards to a possible plea or with regards to seeing if the defendant wants to enter a plea of not guilty and have the case scheduled for trial. We may also address other matters such as bond modifications. If you are a defendant accused of one or more misdemeanor offenses, please remember that you have a constitutional right to remain silent. Anything you say in open court, your statement can and will be used against you. If you cannot afford an attorney, one of our counsel from the Public Defender's Office will be representing you, or an attorney from our conflict defense list. Okay, are we beginning with Courtroom 2?
Yes, Your Honor. It's going to be position number 18, Mr. Carlos Lightsey.
All right, Deputy Moultrie, I'm sorry he beat you to it. Sorry. Okay.
She tried.
She tried. And you said that was 19, I'm sorry.
18.
18, okay.
Your Honor, can we go one and one and one and one, please?
Is it Officer Norris today in Courtroom 2?
Yeah, how you doing, Judge Law?
I'm getting recognize your voice off camera. Okay, I'm doing good. Thank you. Any objection to one-on-one? It looks like they need to get quite a few people resolved.
Yeah, we also have people on the floor too. So
okay,
I'm actually ready.
Let's do one-on-one in the beginning, and then if there's an urgency, we'll get back. All right, Deputy Milton, hold. All right. Okay, Carlos Lightsey, middle name Maurice, case number 20 CR 005-213H, accused of disorderly conduct from July 12, 2019. Mr. Lightsey, you've been advised of your right to remain silent, and your attorney is going to be Mr. Daryl Coleman. Oh, is it Mr. Finling? I think, oh, no, it is Mr. Finling. Yeah, all right, that was the cutoff point. All right. Mr. Finling is your attorney. Mr. Finling, for position 18 is a negotiated plea, correct?
Morning, Judge. And yes, 18 is a negotiated plea.
All right. Okay. So, Mr. Lightsey, may I place you under oath in order to address the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yeah, that's all. You have to say something. Yeah.
Thank you. You may put your hand down. All right. Ms. Sari, good morning. Yes, ma'am. What is the recommendation?
Good morning, Your Honor. The state and the defense have negotiated a plea to 12 months to serve 11 days, credit for time served 11 days, the balance suspended, and for the defendant to comply with all MARTA suspensions. Nothing further.
Thank you. Mr. Finling, does the defense stipulate to factual basis, venue, and ID?
We do, Judge.
Thank you. Mr. Lightsey, have you consumed any medication or alcohol recently?
No, ma'am. What's say now?
Have you consumed any medication or alcoholic beverages recently?
No,
and have you understood the proceedings so far?
Yes, ma'am.
And are you satisfied with Mr. Finling as your attorney?
Yes, ma'am.
If you decide to take this plea today, you would have to give up your constitutional right to go back to court to have a trial before a judge or a jury, to be able to have the assistance of counsel to confront your accuser, present your defenses, challenge the state's evidence, examine witnesses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to the one count of disorderly conduct?
Yield.
Your sentence is 12 months to serve 11 days, credit for time served 11 days. The remainder of the time will be suspended, so your jail time is concluded. You do not have any probation, and you must stay away from all MARTA property in accordance with any suspension that is in place.
Yes, ma'am.
Thank you. That concludes this case. Next case, please.
Finish.
Next case going to be
W. Milton, which one is it?
Position 35. Position 35, Miss Williams, Valerie Williams, come on.
We have State versus Valerie Williams, accused of theft by shoplifting from a January 15, 2020 incident. Ms. Williams, you've been advised of your right to remain silent, and your attorney is Mr. Daryl Coleman. This is going to be a negotiated plea, Mr. Coleman?
That's correct. Good morning. Can everyone hear me?
Loud and clear, thank you.
Thank you.
Ms. Williams, may I place you under oath?
Yes.
Please raise your right hand.
Okay.
Do you solemnly swear the information you provide will be the truth to the best of your knowledge?
Yes.
Thank you. You may put your hand down. Mr. Segura, good morning, sir. What's the state's recommendation?
Good morning. The state's recommendation is 12 months to serve 100 days, credit for time served 50 days, balance probated, an anti-theft course, and a stay away from all Walmart stores. Thank you.
Mr. Coleman, do you stipulate to the factual basis, venue, and ID for this case?
We would so stipulate, we would also ask that the court accept the plea as negotiated, that probation fees be waived for a period of time, and that the probation go non-reporting once Ms. Williams has completed the conditions.
Any objection to non-reporting, Mr. Segura?
No objections.
All right, thank you. I will waive probation fees for up to 3 months for the, let me see, June, July, August, through the end of August. Okay. Ms. Williams, have you consumed any medication or alcoholic beverages recently?
No, ma'am.
And have you understood the proceedings so far?
Yes.
Are you satisfied with your attorney?
Yes.
And is anyone forcing you to take a plea today?
No, ma'am.
If you decide to take this plea today, you would have to give up your constitutional right to go back to court, to have a trial before a judge or a jury, to be able to have an attorney who can help you challenge the state's case, present your own defenses, examine witnesses, confront your accuser, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
Are you entering a plea freely, willingly, and knowingly?
Yes, I am.
How do you plead to one count of theft by shoplifting?
Guilty.
Your sentence is 12 months to serve 100 days, credit for time served 50 days. Your jail time is completed. You don't have additional jail time. You will be placed on probation to complete one anti-theft class, and you must do so within the next 3 months. Your probation fees will be waived up to the end of August of 2022. If you take longer than that to do your class, you will have to start paying probation fees. So complete your class before the end of August 2022. Understood?
Yes.
After you're done with your class, if it is before the end of August 2022, then your probation will be non-reporting.
Okay.
Do you know what that means?
Not exactly.
If you complete your class before the end of August 2022, you don't have to report to probation anymore.
Oh, really? Great.
Okay, I'm glad the bulb lit right there. Okay,
Okay.
thank you.
So one question. Someone will give me the instructions as far as when and where to go to the classes?
You will get then your disposition sheet, and you will report to probation no later than next Tuesday at 132 Mitchell Street.
Okay. Thank you.
All right, good luck.
Thanks.
All right, next to Courtroom 2.
Your Honor, we're gonna go to 6 North, 6 North.
6 North, okay?
Your Honor, before we proceed with the next case, there's an inmate that I need to speak to either in a breakout room or by phone, Christopher Reed, he's position 24.
Position 24, Christopher Reed. Is he in Courtroom 2?
Yes, Your Honor, he's going to the phone right now. Coleman, you can call 404-612-2392.
2392. Okay, thank you.
Well,
All right, I'm sorry. 6 North, who do we have?
I have 25 Sanders.
Oh, that's Mr. Finling. He's Mr. Coleman. He still needs to talk to us.
That's okay. I mean, it shouldn't take that long.
All right.
For
Let's address Mr. Dantero Sanders. Mr. Sanders' case number is 22 CR 002-503C. Mr. Sanders has been accused of simple battery. And Mr. Sanders, you have a right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Coleman. Could you please sit up and pay attention to court? You are in a courtroom. Thank you. All right. Mr. Sanders is position 25, and this is going to be an arraignment. Is that correct, Mr. Coleman?
That's correct. It
All
will
right.
then be reset to a jail jury calendar.
And do you waive reading of the accusation?
We will waive reading.
All right. Mr. Sanders, I understand that you plan to enter a plea of not guilty to the one count of simple battery, which allegedly occurred on October 26, 2019 in Fulton County. This is a charge that has been brought against you by the Fulton County Solicitor General's office pursuant to an accusation. Upon your entry of a not guilty plea, the case will be scheduled for trial. And at the time of the trial, you will have the assistance of counsel to be able to participate in that trial. The prosecutor has the complete burden of proof to prove the charge against you beyond a reasonable doubt and overcome your legal presumption of innocence. If the prosecutor does prevail, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Not guilty.
All right. Your case has been arraigned and further notice for trial. That concludes this matter. Thank you.
Thank you.
Next, we have position number 1, Mr. Braggs, position number 1.
All right. And that is in courtroom 2. All right, Mr. Coleman, go ahead and call the jail, please.
I'm calling them now.
Thank you. Position number 1 is going to be a negotiated plea. Mr. Finling, is that correct?
That's correct, Judge.
All right. We have Cameron Braggs accused of criminal trespass on April 19, 2022 in case number 22 CR 002-324D. Mr. Braggs, you've been advised of your right to remain silent, and your attorney is Mr. Zach Finling. For purposes of the plea, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Mr. Walker, good morning, sir.
Good morning, Judge. The state's recommendation to the one count criminal trespass is 12 months to serve 48 days, credit for time served of 24 days, balance suspended with a stay away from the incident location, 20 Terminus Place Northeast, Atlanta, Georgia, 30326.
All right, thank you. Mr. Finling, does the defense stipulate to the factual basis, venue, and ID?
We do, Judge.
All right. Mr. Braggs, presently, have you consumed any medication or alcohol recently?
No, Your Honor.
And have you understood the proceedings so far?
Yes, Your Honor.
Are you satisfied with the representation of your attorney?
Yes, Your Honor.
And Mr. Braggs, if you decide to take this plea today, you have to give up your constitutional right to be able to go back to court, to have a trial before a judge or a jury, to be able to have the assistance of counsel, to confront your accuser, examine witnesses, challenge the state's evidence, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
Are you entering a plea freely, knowingly, and voluntarily?
Yes.
How do you plead to the one count of criminal trespass?
I plead guilty.
Your sentence is 12 months to serve 48 days, credit for time served 24 days. Your jail time is completed and you do not have probation. The remainder of your time is suspended. However, you will have to stay away from 20 Terminus Place in Atlanta, Georgia, the entire complex, including the restaurants and all that. Do you understand?
Okay. Yes, Your Honor.
If you return to that location, the parking lot, the sidewalk, or any of its shops or restaurants, you will be arrested again for criminal trespass. Understood?
Yes, Your Honor.
All right. That completes your sentence. Thank you.
Mr. Coleman. Your Honor, he's still waiting by the phone. I don't know if Mr. Coleman called.
I'm sorry. I called and I got a voicemail.
What number can we reach you at, Coleman?
Do you want to put it in the chat?
No.
Yeah, put it
Yeah,
put
you
in the
can
chat to
put your
Courtroom
number in the
Two.
chat.
To Courtroom Two, okay.
Yeah, and then, Your Honor, can we go to add-on 2, Mr. Casey?
Certainly.
Morning, Your
Right,
Honor.
Mr. Finling, are you representing Mr. Casey?
I am, Judge.
All right. I'm sorry, Milton you'll be next. You'll be on next, all right. Christopher Casey is accused of loitering and prowling and criminal trespass in case number 22 CR 002-516B from an April 26, 2022 incident. Mr. Casey, you have a right to remain silent and you as so advised, and your attorney is Mr. Zach Finling. This is going to be a negotiated plea. Is that correct, Mr. Finlay?
That's correct, Judge.
All right. Mr. Casey, please raise your right hand for purposes of the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
I'm sorry, repeat that?
I do, Your Honor.
Thank you. All right.
Thank you.
Mr. Segura, what is the recommendation for Mr. Christopher Casey?
For both charges of loitering prowl and criminal trespass, the recommended plea is a time served of 16 days, balance suspended, and a stay away from the petrol truck stop located at 3181 Donald D. Hollowell Parkway. Thank you.
What's the name of the gas station?
Petrol truck stop.
Petro Truck Stop. Okay. On Donald E. Hollowell. Okay. All right. Mr. Finling, and does the defense enter the stipulations of venue, ID, and factual basis?
I do, Judge.
All right. Mr. Casey, have you consumed any medication or alcohol recently?
No, Your Honor.
And have you understood the proceedings so far?
Yes, Your Honor.
And you've been talking of this with Mr. Finling about this case. Are you satisfied with this representation?
Yes, Your Honor.
And is anyone forcing you to take a plea today?
No, Your Honor.
If you decide to take this plea, you would have to give up your rights to go back to court to have a trial in front of a judge or in front of a jury. You would also have to give up your right to have the assistance of counsel, to be able to challenge the state's evidence, present your own defenses, examine witnesses, confront your accuser, and have the state try to prove the two charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to 1 count of loitering and prowling and 1 count of criminal trespass?
I plead guilty, Your Honor.
Your sentence is going to be concurrent for both charges. It would be 12 months to serve 16 days, credit for time served, 16 days, balance suspended. Your jail time is complete. You are not on probation, but you cannot return to the petrol truck stop on Donald E. Hollowell. Otherwise, they will have you arrested and brought back to Fulton County Jail, and we get to do this all over again.
Yes, ma'am.
Thank you. Best of luck.
Thank you.
Deputy Milton, who do we have?
Position 17, Ms. Jordan.
Ms. Jordan is represented by Mr. Coleman. He's still on the phone call. Do you have anyone between positions 1 to 18?
I'm representing Miss Jordan. That was position 17, correct?
Oh, I'm sorry. Yes, you are representing her. Thank you. Okay.
Yes, ma'am.
All right, sorry about that. Miss Lakeisha Jordan is case number 17 CR 0104831. Miss Jordan, you've been advised of your right to remain silent, and your attorney is Mr. Zach Finlay. You have been accused of DUI, driving under the influence of alcohol per se, driving without a valid license, no headlights, failure to obey a stop sign, DUI, driving under the influence of alcohol less safe. And this is from a June 8th, 2016 incident. So I understand this is going to be a negotiated plea. Is that correct, Mr. Finlay?
That's correct, Judge.
All right. So Ms. Jordan, may I place you under oath?
Yes, ma'am.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Sari, yes, you may put your hand down. Thank you. Ms. Sari, what's the recommendation for, well, first of all, which charges are we pursuing on the plea?
Yes, Your Honor, we're pursuing the DUI per se and no processing the remaining.
Okay, all other charges will not be prosecuted. The only charge she's pleading to is DUI per se, correct?
Correct, Your Honor.
All right, and what is the recommendation?
Your Honor, the state's recommendation is 12 months to serve 1 day, credit for time served 1 day, the balance probated, a $1,000 fine, 40 hours of community service, an alcohol and drug evaluation and treatment if necessary, 2 victim impact panels, and a risk reduction course. And Your Honor, this is her second within 4 months of the date of incident.
Is she already on probation for the first one?
If she was, it was back in 2016. So that one may have been resolved.
Yeah,
Okay.
I don't believe she's on probation, no.
Okay. Anything else, Ms. Sari?
Nothing further, Your Honor.
All right. And Mr. Finling, does your client stipulate to the factual basis, venue, and ID?
We do, Judge.
All right, thank you. Ms. Jordan, have you consumed any medication or alcohol recently?
No, ma'am.
And are you familiar or have you understood the proceedings so far?
Yes, ma'am.
And do you understand that in exchange for this recommendation, the state's going to not prosecute you for all the other charges if you plead guilty to this 1 count of DUI per se?
Yes, ma'am.
And you satisfied with the representation of your attorney?
Yes, ma'am.
Is anyone forcing you to take this plea today?
No, ma'am.
If you decide to enter a plea of guilty today to this 1 count, you would have to give up your constitutional right to go back to court, to have a trial before a judge or a jury, to be able to have the assistance of counsel to challenge the state's case, present your own defenses, confront your accuser, examine witnesses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
And has it been explained to you that by taking a plea on a second DUI could have an impact upon your driving privileges as well as any other personal matters?
Yes, ma'am.
How are you pleading to 1 count of DUI per se?
Guilty, Your Honor.
The sentence is 12 months to serve 1 day, credit for time served 1 day. You will report to probation next week on Tuesday at 132 Mitchell Street. And once you are on probation, oh, I'm sorry, Deputy Milton, can we, sorry, okay. No, we need to unmute Court South Annex, please. All right. Once you are on probation, you will need to pay a $1,000 fine during the course of your time on probation. You will need to complete 40 hours of voluntary community service. This can be done at any nonprofit agency except at a school or a church or a religious institution. You can go to a food bank, you can go to Salvation Army, but no schools and no churches. Understood?
Yes, yes, ma'am.
All right. You also need to complete an alcohol and drug evaluation and submit yourself to any treatment that's required. You need to complete 2 victim impact panels and your probation. 2 victim impact panels, that's a presentation on the effects of DUI on victims.
Well, they'll give me a.
Probation will instruct you.
Yes, ma'am. Yes, ma'am. Yes, ma'am.
And you need to do 2 of them.
Yes,
you
ma'am.
also need to do a risk reduction program. It's like a defensive driving program.
Yes, ma'am.
All right.
Yes,
and
ma'am.
all of these will be done at your expenses. I will waive your probation fees for 6 months.
Yes, ma'am.
All right. After that, you will continue to report to probation and pay probation fees.
Yes, ma'am.
All right. Thank you.
Thank you.
Courtroom 2, who do we have, please?
We're gonna let 5 South go next, Judge.
All right, 5 South. Let me get to that screen. I'm sorry.
We have position 23.
All right. Mr. Murphy, who do you have? Good morning, sir. I'm sorry, you're on mute, Mr. Murphy. Good morning.
Good morning. I should have Mr. Guah, G-U-A-H.
Okay, hopefully Courtroom 2 or 5 South or any location. If they have Mr. Guah, they'll bring him as soon as possible. All right, we have position 23, Mr. Adebayo Olufame, and is Mr. Coleman available? There he
Yes,
is.
I'm here, Your Honor.
Excellent, thank you. Mr. Olufame is accused of battery causing substantial physical harm in case number 22 CR 002112E. Mr. Olufame, you have a right to remain silent about the facts of your case. Anything you say about the facts or the allegations surrounding your case, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Daryl Coleman. Mr. Coleman, I understand this is going to be an arraignment. Is that correct?
That's correct. And after that, reset to jail jury.
All right. Mr. Olufame, I've understood that you plan to enter a plea of not guilty. The prosecution office of the Fulton County Solicitor General has brought this accusation, charging you with the misdemeanor offense of battery causing substantial physical harm, allegedly occurring on April 22nd of 2021 in Fulton County. This is an allegation, and you are entitled to a trial by judge or by jury upon your entry of a not guilty plea. At the time of the trial, the prosecution would have the complete burden to prove the charge against you beyond a reasonable doubt. Mr. Coleman, I just want to confirm, do you waive a reading of the accusation?
We will waive reading.
Okay. As I was saying, the prosecution has the complete burden to prove the charge against you beyond a reasonable doubt and overcome your legal presumption of innocence. If the prosecution succeeds, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, if we can unmute 5 South, please. Given this information, Mr. Olufame, how do you plead?
Not guilty.
Repeat, please.
Not guilty.
All right. I will accept your not guilty plea. The case has been arraigned and it will be scheduled for trial. Mr. Coleman, are you all seeking a bench or a jury trial?
This would be jury.
Okay, thank you. Next case, South Annex. Oh, no, sorry, not South Annex, Courtroom 2.
This is position 2, Mr. Brown.
I have Jonathan Brown accused of theft by shoplifting from a September 24th, 2021 incident, and the accusation is 22 CR 002644C. Mr. Brown, you've been advised of your right to remain silent. Your attorney is Mr. Zach Findling. As this is going to be a negotiated plea, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Mr. Walker, what's the recommendation for Mr. Brown?
State's recommendation is 12 months to serve, 28 days, credit for time served of 14 days, balance probated, a theft course, 45 hours of community service, a stay away from the incident location, Home Depot, located at 6400 Peachtree, Dunwoody Road.
Thank you. Mr. Findling, does the defense stipulate to the factual basis, venue, and ID?
We do, Your Honor.
All right. Mr. Brown, have you consumed any medication or drugs or alcohol recently?
Oh, Your Honor.
And so you've understood the proceedings so far?
Yes.
And in your discussions with your counsel, are you satisfied with this representation?
Yes, Your Honor.
And is anyone forcing you to take a plea today?
No.
If you decide to enter this plea of guilty to theft by shoplifting, you would have to give up your constitutional rights to specifically go back to court, have a trial in front of a judge or a jury. You would have to give up your rights to have the assistance of counsel who can assist you in challenging the state's evidence, present your defenses, be able to confront your accuser and examine witnesses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
Are you entering a plea freely, knowingly, and voluntarily?
Yes, Your Honor.
And how do you plead to one count of theft by shoplifting?
Guilty.
Your sentence is going to be 12 months to serve 28 days, credit for time served 14 days. Your jail time is completed And if you have no other holds at the jail, you'll be released to report to probation. You will have to report to probation next Tuesday at 132 Mitchell Street before the close of business. When you're on probation, you will complete a anti-theft class, complete 45 hours of voluntary community service that must be completed at any nonprofit agency, which is not a school and not a religious institution. You will also stay away from the Home Depot store at 600 Peachtree Dunwoody Road in Atlanta, Georgia. Just FYI, normally they post your picture in all Home Depot stores, so you might want, if you go to a different Home Depot store and they ask you to leave, you may have to leave. Understood?
Yes, ma'am.
All right. Is anything else, Mr. Finley?
Judge, I'm sorry, I didn't mention before, if once he completes the theft class and the community service, if he could be on a non-reporting, Judge.
Any objection, Mr. Walker?
No objection, Your Honor.
All right. So, sir, if you complete your community service, your 45 hours of community service, as well as the anti-theft class, then your probation will be non-reporting. In other words, you don't have to report. You're still on probation, but your reporting obligations will end.
Yes, Your Honor.
Thank you. That completes the case.
Position 11, Ms. Hammock.
Okay, we have Aisha Hammock, accused of theft by taking from September 19, 2013, case number 15 CR 008-402A. And
this was a hold for announcement, Judge, and this is going to be a negotiated plea.
okay, thank you. Ms. Hammock, you've been advised of your right to remain silent. Your attorney is Mr. Zach Findling, and I understand this is going to be a negotiated plea. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. All right, Mr. Walker, Ms. Sari, what is the recommendation for Ms. Hammock?
Yes, Your Honor. The state's recommendation is 12 months to serve 53 days, credit for time served 53 days, the balance probated, an anti-theft course, restitution in the amount of $20 to the victim. Her name is Edith Hammonds, EDITH, last name HAMMONS, and a stay away from the incident location, which is 400 Formwalt, FORMWALT Street in Atlanta. Nothing further.
Mr. Findling, does your client stipulate to the factual basis, venue, and ID?
We do, Judge. And since finances are an issue in Ms. Hammock's life, we are asking for the probation fees to be waived. And also, once she completes that anti-theft course and once she pays that $20 restitution, if her probation could either be terminated, but if you're not inclined, not reporting, Judge.
How long will it take her to pay the $20?
She said there wouldn't be a problem, so I'd hope relatively quickly.
Okay.
And Your
right.
Honor, I'm
Yes,
sorry, I gave the wrong incident location.
problem.
I would like to correct that. For the record, it's 830 Woods Drive.
Woods Drive in Atlanta, Georgia?
Yes, Your Honor.
All right. And the victim still wants her $20?
We've reached out to the victim. I don't believe we were able to get in contact with her in preparation for this calendar, but in the report, it did state that she wanted to pursue charges.
From 2013?
Correct.
All right. I'm going to suspend the $20. Ms. Hammock, first of all, have you consumed any alcohol or medication recently?
No.
And have you understood what's been going on so far?
Yes.
All right.
No.
It's okay to be honest, because sometimes even
No, I
I don't
don't.
understand. So if you don't understand, that's perfectly fine. We are in the middle of a plea hearing, which this is a case from 2013. You were charged with theft by taking from one Edith Hammonds, who wants her $20 back.
That's my mother.
Okay. And right now, you've spoken to your attorney, and from what I understand, you are willing to plead guilty to the charge in exchange for, serving time and being on probation to pay back the $20.
Okay.
All right?
My mother's dead. My mother's dead.
Okay. And also you need to stay away from 830 Woods Drive, the location.
Okay.
All right. Now, this is information that you've already discussed with the attorney. Do you need to ask him any more questions?
No.
All right. And the requirement of to pay back the $20, I'm canceling that, so you don't have to do that.
Okay.
All right. So if you want to still plead guilty to the charge, the sentence will be time served and you're done with the case. That's it.
Yes. Yes.
And just want to verify, Judge, so we're not doing, just so I understand, the anti-theft course? No.
Yeah, she's out. She's done.
Okay, perfect. Okay.
Ms. Sari, from what I understand, the alleged victim is deceased.
Yes.
We don't have any record of that, but we weren't able to reach her, so that very well could be the situation.
All right.
That's my mother. That's my mother, and she died.
I'm so sorry, Ms. Hammock, but right now I'm just trying to decide what type of sentence, and the sentence will be just basically the time you've been in jail.
No objection from the state, Your Honor.
Thank you. Ms. Hammock, as I was saying, do you understand what's going on now?
Yes, I do.
All right, good, good. And you've been having discussions with Zach Findling, your attorney. Are you satisfied with his representation?
Yes, I am.
All right. Is anyone forcing you to take a plea today?
No.
And Ms. Hammock, listen very carefully. If you plead guilty today, you will not get a chance to have a trial in front of a judge or a jury. You won't be able to go back to court. You won't be able to challenge the state's case. You won't be able to present your defenses. You won't be able to have an attorney sitting by your side to say objections and that my client's not guilty and to argue your case before a jury. All these rights you will have to give up if you decide to plead guilty today, including the right to have the state try to prove the charge against you beyond a reasonable doubt. So are you willing to give up these rights in exchange for the pleading guilty and getting a time served sentence?
Yes.
And how do you plead to one count of theft by taking from 2013?
Guilty.
All right, your sentence is time served, which is 53 days, 12 months to serve 53 days, credit for time served 53 days, and that concludes the case. Thank you.
Your Honor, we're going to 4 South. We're going to go to 4 South.
Okay.
All right, next case, position 10.
I hope somebody is monitoring this because I'm playing Hollywood Squares over here. So 4 South is next, and then I think is back to Courtroom 2. So
that's
South. Okay. All right. And I do beg your pardon. Who am I addressing at 4 South?
Position 10.
10. Thank you. All right. Mr. Murphy, are you ready? Dennis Murphy?
Yes, Your Honor.
All right. We have Mr. Say Gua Jr., case number 22 CR 002-577F. Mr. Gua has been accused of battery domestic violence from April 27, 2022. Mr. Gua, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you today is Mr. Dennis Murphy. Do you see Mr. Murphy on the screen?
Yes, I do.
Thank you. Mr. Murphy, what is your announcement today?
Judge, this is, I believe right now, there is a current $4,000 cash bond. I would like to address that issue of a bond modification.
All right, has this case been arraigned? I'm sorry.
I'm not sure, Your Honor. We arraigned an older case 2 days ago. So perhaps this one has not been arraigned. So we would tender a not guilty plea and request jury trial. I'd spoken with Mr. Walker, and there was a revised offer that we would not be accepting. So we will enter our not guilty plea and waive arraignment and request jury trial and then address bond, Your Honor.
When you say waive arraignment, I just need to clarify. So I can either arraign the case right now and you can waive a reading of the accusation, or you would need to file an actual waiver of arraignment to our litigation manager before the close of court. Which one would you like to do?
Judge, since I'm going to have, we'll just waive the reading, and I will provide that document, Judge, later today, since I have to come back down to the court.
Okay, so just to clarify, you are filing an actual written waiver of arraignment to this case, entering a not guilty plea on behalf of your client, correct?
Correct.
Okay, so Ms. Grace, please make a note that Mr. Murphy will be submitting a written waiver of arraignment. And you can either, Mr. Murphy, you can either file it on your own or you can email it to melissa.grace@fultoncountyga.gov.
Will do, Judge.
Thank you. All right, so this case has been arraigned and Mr. Guas at the present entered a plea of not guilty to this charge. So we will address his motion to modify his bond. A $4,000 cash bond was issued on April 28, 2022. You may proceed, Mr. Murphy.
Judge, my client is, he receives Social Security disability income, approximately $840 a month. And he has some part-time work as a apprentice bricklayer that might provide an additional $700. So he's able to subsist on about $1,500 a month. A $4,000 cash bond at this point amounts to no bond. He has to, and given the circumstances and this alleged victim, he's going to have to go find a new place to stay. And I'd ask the court to consider a reasonable surety bond under the circumstances. I do have a way to reach out to his sister, so I'm confident we can get some independent housing. And he used to stay at 1631 Stanton Road Southwest in Atlanta, 30311, and that is not the same address as the alleged victim in this accusation.
Mm-hmm.
And again, Judge, he's a lifelong resident of Atlanta, and he is a Social Security disability income recipient. But he has no other assets to go on, no credit, so to speak. And we'd ask for a reasonable surety bond therein, Your Honor.
All right. And what is the status of the bond in the case 21 CR 001394F? I do see
Judge.
there was a proposed order to modify the bond to $5,000, but I don't see that it was signed.
Yes, Judge. I submitted that order to the clerk yesterday morning at about 10:30, and that bond was a $5,000 surety bond. But that order was submitted yesterday at about 10:30, between 10:30 and 11, to the clerk's office.
And was that at the SAP calendar or was that by the division judge?
That was at the SAP calendar from Tuesday. Judge Morrow had said it.
Okay. And just to know.
Initially, yeah. Judge, since on the older case, since my client was FTA back in March, Judge Richardson had set a $1,000 cash bond, and Judge Morrow
amended it to $5,000.
Yes, he changed it. He modified it. But that order is in place. If it hasn't been signed, my apologies, but I had submitted it to the clerk yesterday about 10:30 a.m.
And procedurally, I want to note that when that case was initially accused, your client received a signature bond through the jail. Through his FTA, he received a $1,000 cash bond, which was subsequently amended to a surety bond. And the $4,000 cash bond is based on a reoccurrence involving the same victim. So we'll proceed from that point onwards.
That's correct. They are alleging that the same victim is involved in this new charge.
All right. So from what I can gather then, at least anything that's transpired from March of 2021 to the present for this case, right up to this point, the only modification has been to institute a surety bond in his companion case. There are no other changes.
Not that I was aware of, Judge.
Okay. All right. Ms. Sari, what's the state's position?
Yes, Your Honor. The state's position is we have the same understanding that you just went through procedurally, but just to indicate that the defendant does have 3 open cases. 2 are battery family violence against the same victim, where he was given that surety or that signature bond. He failed to appear twice on that case. He was given a no further violent contact order and then subsequently picked up this case. So due to the defendant's risk of reoffending against the same victim, his risk to intimidate the victim witness, and also the fact that, Your Honor, he has contacted the victim from the Fulton County Jail. The state's recommendation for the plea is 12 months to serve. So as far as bond modification, there's no change in circumstances. He's FTA'd twice, picked up a subsequent charge. So, and Your Honor, you did set this bond at $4,000 cash. So we do ask that the bond remain as set, nothing further.
What evidence do we have that Mr. Gua has attempted to reach Ms. Lady Bashir after April 28, 2022?
Your Honor, one of our ASG Walker, he was actually on a call with the victim, and she had the defendant on the other line and was attempting to have ASG Walker speak to the defendant, which is improper for ASG Walker to do. So he hung up the phone and did not speak with the defendant. So there was contact while the defendant was in custody.
All right. Can the victim call into the jail to speak to the inmate, or do the inmates have to call out to reach out to people outside? Which way does it work?
The inmates have to call out, Your Honor.
Right.
I just want to put that on the record.
The inmates have to call out. I'm sorry to cut in, but the victim does have 2 cell phones. When I reached out to her in regards to Tuesday's calendar, I introduced myself and she said, "Oh, you're right on time. I'm on my other phone with the defendant, Mr. I forget how you pronounce his last name. Wow. Say something. This is Mr. Gua. This is the prosecutor. Say something. I've changed my mind." Yeah, I think this is important to note for the record. I changed my mind. This is my husband. I no longer want to prosecute. And of course, he was reiterating what she was saying in the background. And of course, he said, "Ma'am, this is improper. I have to terminate the call." But I think that's important to note, because when we first made contact with her at the C calendar, she advised to the victim advocate that she was in fact intimidated. She was concerned for her safety. She said he was a much larger individual than herself. She was unable to defend herself, and she wanted to proceed with the charges. From that date to this past Tuesday, her position has changed. Obviously, the defendant has made contact because they attempted to arrange some type of conference call with me, if you will. And I think that just goes to show the importance of the no contact order when it comes to these type of cases, because once the defendants make contact and we go through the cycles of violence, the victims, they no longer want to cooperate. And we know the rest of the story. So I'll leave it at that. But the defendant has been calling the victim. She confirmed it. I heard his voice. And he also attempted to speak with me, which I obviously did not engage.
All right, Mr. Murphy, a rebuttal?
Judge, from that, I mean, she was trying to patch my client in. I mean, at that point, where's the intimidation?
No, sir, that's not the point.
Yes. What I would
Understood.
say, Judge, I would say to this is that we'll find independent housing, Your Honor. He had missed that first court, the older court case. His phone was disconnected. He advised me that he never got the court notice. I advised him that I tried to reach out to him. He did not have a new phone, but he assured me that he'll attend the court dates. I have also advised him that the court, given these circumstances, is not going to allow any contact whatsoever, and that you're going to have to find independent housing and stay clear of the alleged victim until these cases are resolved, Judge. And again, given these circumstances and his limitations, I'd ask for a reasonable surety bond under the circumstances.
All right.
Your Honor, briefly, if I could just say something. I know counsel gave the defendant's sister at the new potential address. I just like to note for the record that it is his sister's child who is the victim of the reckless conduct that he also has open currently. So I just wanted to bring that to the attention of the court.
All right.
I was asleep when she walked out. I work. I do.
Mr. Guay, you're best to remain silent. We'll talk later.
Mr. Guar has a case 21 CR 006-126E, in which it's assigned to Judge Morrison for a November 8th, 2021 incident. I think I bring that up because I think the clerk's office has to transfer that case over to Judge Richardson, who has the earlier case, State versus Mr. Guar, 21 CR 001-394F. That is the incident from March 24th, 2021. In both cases, we have noted that Mr. Guar has got failures to appear. And now in his new case, 22 CR 002-577F, Mr. Guar is accused of battery domestic violence against the same alleged victim, Miss Lady Bashir. The initial bond of $4,000 was not only based on the allegations of a repeat occurrence involving the same victim, but also based on the allocutions that were made by the victim at the initial appearance calendar. And based on all this information, the court had issued a $4,000 cash bond. Since then, Mr. Guar has shown conduct that indicates that he's not open to complying with court orders. His actions of reaching out to the victim by phone from the Fulton County Jail, when the bond order expressly requires him to have no further contact with Lady Bashir, indicates that he doesn't have any intentions of complying with a court order. The request for a bond modification is denied.
Thank you, Your Honor.
Thank you.
Thank you, Judge.
That's all I have. I'll be down with the waiver. Thank you, Your Honor.
Thank you, Mr. Murphy. Thank you. All right, Courtroom 2, next case, please.
Position number 20, Mr. Merritt. Position number 20.
All right, we can mute 4 South, please. We have Montrez Merritt. Is that correct? Is
Yes,
that
ma'am.
Mr. Merritt?
Yes, ma'am.
Thank you. Mr. Merritt's case is 14 CR 003-229, in which he was accused of driving while license suspended or revoked and misdemeanor possession of marijuana from June 9th, 2012. Mr. Merritt, you've been advised of your right to remain silent, and your attorney is going to be Mr. Darrell Coleman. And Mr. Merritt, if you please raise your right hand for purposes of the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Ms. Sari, what's the recommendation for Mr. Merritt?
Yes, Your Honor. The state's recommendation is 12 months to serve 16 days, credit for time served 16 days, and the balance suspended.
Thank you. Mr. Coleman, do you stipulate to the factual basis, venue, and ID?
We will so stipulate to a factual basis, venue, and ID. We just ask that the court accept the plea as negotiated.
All right. And Mr. Merritt, are you under the influence of any kind of medication or alcohol?
No, Your Honor.
And have you understood the proceedings so far?
Yes, Your Honor.
And are you satisfied with Mr. Coleman?
Yes.
Good. If you decide to take a guilty plea to the And sorry, Ms. Sari, before I continue, have you all null crossed any of the charges?
No, Your Honor,
Okay.
it's for both.
All right, so this will be a concurrent time served for both charges. If you
That's
decide to plead guilty to both these charges, you would have to waive your constitutional right to go back to court, to have a trial in front of a judge or a jury, to be able to have the assistance of counsel, to contest the state's evidence, present your defenses, examine witnesses, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights? Hello? Mr. Merritt, do you want me to repeat what I just said? I'm sorry, it's on mute. Courtroom 2, you're on mute. I can hear Mr. Coleman, but I can't hear Courtroom 2. Sorry. I think Courtroom 2.
Your Honor, our internet is a little unstable.
Okay, sorry about that. Mr. Merritt, did you hear me recite that if you decide to plead guilty, you would have to give up your constitutional right to go back to court, to have a trial in front of a judge or a jury, to be able to confront your accuser, examine witnesses, and have the state try to prove the charges against you beyond a reasonable doubt?
Yes, Your Honor.
And are you prepared to give up those rights?
Yes, Your Honor.
How do you plead to the charges brought against you?
Guilty.
The sentence is time served. Your obligations for this case is concluded. Thank you.
Thank you.
Thank you, Your Honor.
Next, we have position 24, Mr. Reed, Christopher Reed. Position
All right. South Annex, you're on deck. I'm taking
Yes, ma'am.
Mr. Reed. Thank you.
Position 21, Middleton.
Okay, Middleton will be right with you. Thank you. Just hold. Courtroom 2, Mr. Reed. And that was position 24, I believe. Was that Mr. Coleman? Mr. Coleman, you've already spoken to your client?
Yes, I did, Your Honor. Mr. Reed is going to be reset to jail jury. He wants to hire his own counsel.
Okay. And so Christopher Antoine Reed has been accused of DUI under the influence of alcohol, less safe, reckless driving, speeding, fleeing or attempting to elude a police officer, operating a vehicle with an expired tag or having an unregistered vehicle, and violation of the conditions of a limited driving permit. The alleged incident date is from February 24, 2019, accusation number 19 CR 008669B. Mr. Reed, you've been advised of your right to remain silent, and your attorney, well, at the present time is Daryl Coleman, but I understand that you want to seek your own counsel. Is that correct?
Yes, Your Honor.
All right. So in the meantime, I'm going to arraign your case, which means that we will accept a plea of not guilty and have the case on track for trial, whether it be before a judge or a jury. Mr. Coleman, I'm still deeming you to be representing Mr. Reed. So do we waive a reading of the accusations?
We will waive reading.
All right. So, Mr. Reed, these are the charges I've just listed against you in this accusation are misdemeanor offenses, and you are legally presumed innocent of these charges until the case goes to trial. Upon your entry of a not guilty plea to these charges, the case will be on track for trial before the division judge. At the time of the trial, the prosecutor has the complete burden to prove the charges against you beyond a reasonable doubt. If the prosecutor prevails, and you are convicted of one or more of these charges, you could be sentenced to up to a year in prison and or up to $1,000 fine for each convicted offense. The sentences could be served concurrently, that is together, or consecutively, that is separately. Given this information, how do you plead?
Not guilty, Your Honor.
All right. Your case has been arraigned and is going to be further notice for trial. That concludes this case.
Thank you, Your Honor.
All right, South Annex, we have position number 21. And Courtroom 2, I'll be with you shortly. Please mute your screen. We have Vivian Middleton accused of loitering and prowling and possession of a drug-related object from case 20 COB 000474. And Ms. Middleton, you've been advised of your right to remain silent, and your attorney is going to be Mr. Daryl Coleman. Mr. Coleman, this is position 21, and we are addressing a plea. Is that correct?
That's correct.
All right. All right. Ms. Middleton, if you please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Segura, what's the recommendation for Ms. Middleton?
The recommended plea is 12 months to serve 150 days, credit for time served 75 days, balance probated, an ADET, $100 fine, and a stay away from the Citgo gas station located at 3567 Martin Luther King Jr. Drive, Southwest Atlanta. Thank you.
And just to clarify, she's doing the ADET. Is she abstaining from any substances other than illegal drugs?
Yeah. Besides illegal drugs, no.
All right. What's the ADET for?
And it's mostly drugs that cocaine, mostly.
Okay. So it's for drug substances as opposed to alcohol.
Yes.
All right. Thank you. All right. Mr. Coleman?
Yes, I did want to ask Ms. Middleton. Ms. Middleton, would you rather pay the $100 fine or do 10 hours of community service?
10 hours of community service.
Okay. Yeah, Your Honor, we would ask that the court accept the plea as negotiated. We would ask that the $100 fine be converted to 10 hours of community service. That probation would terminate once she's completed the evaluation and the community service, and that probation fees be waived.
Does she have a good address?
I did not inquire. I'm assuming that she does. Do you have an address, ma'am?
Yes, sir.
All right, you can give your address to Deputy Milton, who's standing next to you, and she'll put that in the chat to Melissa Grace. Deputy Milton, it will be to Litigation Manager, LM Melissa Grace.
Okay.
All right, and we'll need to send that information on to probation as well. Probation today is Miss Victoria Vaughn. You can send that information to Victoria Vaughn as well. You'll see her on the participant list. Okay?
Okay.
Thank you. Thank you. All right. So anything else, Mr. Coleman? Do you stipulate to the factual basis, venue, and ID?
We will so stipulate.
All right. All right. Ms. Middleton, if you could just pay attention, you can give your address in a few moments, okay? All right. Ms. Middleton, presently, for purposes of this plea hearing, have you consumed any medication, illegal drugs, or alcoholic beverages?
No, ma'am.
And have you understood the proceedings so far?
Yes, ma'am.
And are you satisfied with the representation of Mr. Coleman?
Yes, ma'am.
If you decide to take this plea today, in other words, plead guilty to loitering and prowling and possession and use of drug-related objects, you would have to give up your constitutional right to go back to court, to have a trial before a judge or a jury, to be able to have the assistance of counsel to challenge the state's evidence, present your own defenses, examine witnesses, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
Is anyone forcing you or inducing you to take a plea today?
No, ma'am.
How do you plead to one count of loitering and prowling and one count of possession and use of drug-related object?
Guilty.
Your sentence is 12 months to serve 150 days, credit for time served 75 days. If you have no other cases holding you at the jail, you'll be released and you will have to report to probation by next Tuesday at 132 Mitchell Street in downtown Atlanta. Do you understand?
Yes, ma'am.
When you report to probation, once you're on probation, you will need to complete an alcohol and drug evaluation for any illegal drug substances. If treatment is required, you will submit yourself to that treatment. You will also complete 10 hours of voluntary community service at any nonprofit agency, which is not a school and not a church. You will also stay 200 yards away. That's the length of 2 football fields from the Citgo gas station at 3567 Martin Luther King Jr. Drive. That means you can't go on the sidewalk, you can't go in the parking lot, you definitely cannot go inside the gas station. And probably if you're across the street, you just need to keep on walking. Do you understand?
Yes, ma'am.
All right. Ms. Deputy Milton will send us your current mailing address to litigation manager Melissa Grace and our probation officer Victoria Vaughn. Thank you. Courtroom 2, who do we have, please?
Got our last person, Mr. Van, position number 28.
Oh, okay. Have I concluded with everybody else in courtroom 2?
Yes, Your Honor. Courtroom 2. But we
All right.
still have people on the floors.
Okay.
Yeah.
Dimple Doug, will you please mute your screen? Will the host please? Thank you.
And just one more left over here, the South Annex, Your Honor.
Okay. I'm sorry, I heard 28, is that correct?
That is correct, Your Honor. Position
All right.
28.
Okay. We have Norvell Thomas Van. Are you Mr. Van?
Yes, Your Honor.
Thank you. Mr. Van, you've been accused of 2 counts of theft by taking from May 11, 2020 and May 13, 2020. With regards to both these charges, you've been advised of your right to remain silent and your attorney is Mr. Coleman. And this is going to be a negotiated plea?
That's correct.
All right. Mr. Van, if you please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Mr. Segura, what is the state's recommendation? Are you pursuing both charges?
Yes, for both of them.
All right.
The recommended plea is 12 months to serve 22 days, credit for time solved 11 days, balance probated, and anti-theft calls, and a stay away from target located at 2539 Piedmont Road, Atlanta. Thank you.
Thank you. All right. Mr. Coleman, do you stipulate to the factual basis, venue, and ID?
We would so stipulate, we would ask that the court accept the plea as negotiated. We'd ask that probation fees be waived for a period of time, that probation would terminate once he's completed the theft course. Also, Mr. Van told me yesterday that he resides in Smyrna, so I asked that he be allowed to report to probation via mail.
Mr. Segura, do you have his GCIC on any other theft charges or theft by shoplifting?
I could check.
Or if pretrial is present, Ms. Harrison, good morning.
Good morning, Judge. I don't have a GCIC.
Okay, that's fine. Yeah, I don't, Mr. Segura, do you have any objection to a non-reporting probation if he completes the anti-theft class?
I have his GCIC and let's see. No, as it seems like he had some charges, but they were dismissed. So
Okay.
I have no objection.
All right. So, Mr. Coleman, rather than doing probation by mail, it will be non-reporting if he completes the anti-theft class.
That's fine.
All right. Okay. So, Mr. Van, have you consumed any medication or alcoholic beverages recently?
Your Honor.
Repeat, please.
No, Your Honor.
And are you satisfied with the representation of your attorney, Mr. Coleman?
Yes, Your Honor.
Is anyone forcing you to take a plea today?
No, Your Honor.
And Mr. Van, if you decide to enter a plea of guilty to these 2 counts of theft by taking, you would have to give up your constitutional rights to challenge these charges in a court of law. Specifically, you would have to waive your right to have the assistance of counsel, to attend a trial before a judge or a jury, to be able to confront your accuser, examine witnesses, have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
And how do you plead to the 2 counts of theft by taking?
Guilty, Your Honor.
Your sentence is 12 months to serve 22 days, credit for time served 11 days. Your jail time is concluded and you will be placed on probation. You will report to probation at 132 Mitchell Street by next Tuesday. While you're on probation, you will complete an anti-theft class. I will waive your probation fees for the months of May and June. By the end of June, you should have completed your anti-theft class, after which your probation will then be non-reporting. Understood?
Yes, Your Honor.
If you don't complete your class by the end of June, then you will continue to report to probation in Fulton County, in Atlanta, and still pay and start paying probation fees.
Yes, Your Honor.
All right. That concludes this case. Thank you.
Thank you, Your Honor.
All right, Courtroom 2, that will complete all cases in Courtroom 2. We're moving on to South Annex. Who do we have, please?
Add-on 1, Ms. Adams.
We have Kelly Adams, 22 CR 002-426A.
It's Killy, not Kelly, Killy. You pronounce it wrong. It's Killy Adams, not Kelly, Killy.
All right, Miss Killy. Miss
Right,
Killy
thank
Adams.
you. Thank you.
No problem. Ms. Kelly Adams is accused of simple battery, 2 counts of criminal trespass, and 1 count of disorderly conduct from April 22nd, 2022, in case number 22 CR 002-426A. Ms. Kelly, you've been advised of your right to remain silent about the facts of the case, and your attorney is Mr. Darrell Coleman. Okay. And Mr. Coleman, I understand this is going to be a plea.
That's correct.
All right. Ms. Adams, if you please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. All right. Mr. Segura, what's the recommendation for Ms. Adams?
The recommendation is 12 months to serve 42 days, creditor time served 21 days, balance probated, and MHET. No further contact with Bonita Moray. Bonita spelled B-E-R-N-I-T-A. Moray, common spelling. Restitution to Tony Moray Sr.'s cordon damage, and stay away from Georgia State University at 175 Piedmont Avenue, Northeast Atlanta. Thank you.
Is that a specific building at GSU property?
In the dining hall area, but kind of want to have stay away in general from the entire university.
So it's the 175 Piedmont. 175 Piedmont Avenue in Atlanta, Georgia. Is that correct?
Yes. Yes.
All right. I understand this is a negotiated plea, correct, Mr. Coleman?
Well, except for the restitution, Your Honor, we would ask that the restitution be struck if the state does not have a specific verifiable amount for the restitution at this time.
All right, Mr. Segura, do you have a specific amount?
I have $4,000, Your Honor. I'll pay the restitution in full and the probation.
Ma'am, please don't speak at this time.
Yesterday we attempted to make contact with Mr. Tony Moray, but it went directly to voicemail, and he has yet to make contact.
All right. Well, I understand that the defendant has stated that she will pay up to $4,000. So we will let the Mr. Segura, let the victim know that the victim is open, that the defendant's open to paying those damages, and those damages would need to be submitted to the probation office. Mr. Coleman?
Your Honor, we would still be objecting to any restitution amount that's not specified and verified at this time.
All right, but based on the victim's outburst, I understand that she's willing to pay up to $4,000. So, Mr. Segura, please ask your contact person at GSU to submit a bill to probation. Mr. Segura?
Yes.
All right. So anything else, Mr. Coleman?
No, Your Honor, we just asked that the court accept the plea as negotiated. We would ask that the probation fees be waived for a period of time, that the probation either terminate or go non-reporting once Ms. Adams has completed the mental health evaluation.
It's done. I took one here. I'm good. It's done.
All right.
I took an evaluation here.
All right. But I'm going to order another one.
2 weeks ago, I know. Okay,
All right, thank you.
okay.
Mr. Segura, any objection to non-reporting?
No objection.
All right. I'm actually going to waive all probation fees, but I'm going to require her to report every month. And just to make sure that she maintains the terms of the probation, not get arrested again, complies with any MHET that's ordered, and that she continues to pay the restitution so ordered. All right. So Ms. Adams, would you still like to proceed with the plea?
Yes, I'd like to ask you a question too. When is this evaluation gonna come? Because yesterday mental health came through. They weren't talking to me at all.
I'm ordering out another one, and
I've had two.
okay. So
I had one in Rice County and I've had one here, so I have to get a third one, Judge.
Third one's the charm.
Okay, when is that?
While you're on
Probation will contact you and set it up.
Oh, it's at probation.
Yes.
Can I file charges for harassment when you come up negative?
That's something that you would need to take upon your own, ma'am.
Yeah, I think I'm gonna counter sue, sir. I think so. Let's go back to you, Judge. Yeah,
So
what's up?
next question I have, Ms. Adams, is that would you like to still proceed with the plea? Because you still
Yeah,
have the
my
right.
plea is guilty, ma'am. Guilty. I'll take a guilty plea.
All right. Mr. Coleman, you've already stipulated to the factual basis, venue, and ID. So
Yes.
Ms. Adams, have you consumed any medication or any kind of alcohol recently?
No, I'm good.
All right. And in your discussions with Mr. Coleman, have you understood the proceedings so far?
Sure. Yes,
And
ma'am.
are you satisfied with his representation?
I thought my lawyer was somebody else, but it's okay. I'm
All right. So you're satisfied with his representation?
He's all right.
Okay, I'll take that. And is anyone forcing you or inducing you to take a plea today?
No.
And in being able to take a plea today, you would have to understand that you will be giving up your constitutional rights to challenge these charges in a court of law. You will not get a trial before a judge or a jury. You will not get an attorney to sit by your side and challenge the state's evidence, to present your own defenses, to confront your accuser, examine witnesses, have the opportunity to challenge and argue your case before a judge or jury, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up all these rights?
Yeah, I already have.
All right. And in taking this plea, you will be placed on active probation for the next 12 months, less the time you've served in jail.
Judge, I bring it to your attention, I get disability for physical handicap. I've been injured 26 times. I've even got injured here twice and I was hospitalized. The day of the incident, I was also hospitalized and brought here from the hospital after leaving the other jail, the male county jail, to come to the women's jail. It's all physical, but I'll take a third, what do you call it, evaluation.
All right.
Okay,
And
for you, Judge, because I like you, because I don't know him. I
thank
like
you.
you.
But in, all right, if you decide to take this plea, you do understand that you'll be reporting to probation every month. I'm waiving all your probation fees. And that based on your statement, you will also pay restitution up to $4,000 based on the bill that will be submitted by Georgia State University.
No more, no less. I got it.
Okay. All right. So how do you plead? To
Guilty.
1 count of
Guilty.
simple battery,
Guilty.
2 counts of criminal trespass,
Guilty.
and 1 count of disorderly conduct.
Guilty.
Your sentence is going to be 12 months to serve 42 days, credit for the 21 days you've been in jail. So your time at the jail is completed. You will be on probation for the remainder of the 11 months. While you're on probation, you will complete a MHET as ordered by your probation officer.
What is that?
The mental health evaluation.
Another one. That's the 6th one in 6 months since I moved here. That's, that's harassment completely. But I'll deal with you later.
And,
what's the next
and
one?
if the evaluation says you do not need treatment, then you do not need treatment. But if you're required for additional
This
treatment,
is the sixth one in 6 months. since
We
I-
understand, ma'am. Hopefully this will be the last one.
Yeah. Tell it to the judge. Okay, let her talk. Let's go back to her. Whatever.
while you're on probation, you shall also have no contact with Bonita Murray, and you shall stay away from the Georgia State
No
University.
problem.
Identified as 175 Piedmont Avenue, and you cannot return to that building.
No problem.
And as per your representation, you will be liable for restitution up to $4,000. That will be a bill submitted by GSU to the probation office. All
That's
payments,
for the damages done to the automobile or the lady that I hit.
that is a
Okay.
matter that you will take up in civil court, but that will have no bearing.
I have one question. I heard the lady.
Let me finish a
Well, the
sentence.
answer like
Let
I
me
did.
finish a sentence and then we'll address your concern.
Okay.
Based on your outburst, you have indicated that you will be responsible for up to $4,000 in damages to GSU property. And that is the amount that you will pay.
There was no damages to GSMU property.
Like I said, they will submit a bill to probation. And
No,
based
okay.
on your representation, your admission, that is your liability. Whatever damages that you believe you are owed, that is a matter you can pursue in a civil case. That is
Okay.
your right. And
Thank
that will be no set off from
Grazie.
restitution that is to be paid in this criminal case.
Thank you.
All right. Okay,
Grazie.
any questions, Mr. Coleman?
No, thank you, Your Honor.
All right, remember to report to probation at 132 Mitchell Street every month. Thank you.
What day? What's the first day, ma'am? The first
I
day.
think
The first appointment. I don't know where that is. Where
it's
is it?
next Tuesday,
Sunday.
and that would be on, let me make sure I pull up the calendar. That would be on May 17th before 4 o'clock.
Yes, ma'am.
Thank you.
Thank you.
Thank you, Your Honor.
Grazie.
Thank you, Deputy Milton. Okay, we have 4 North. Who do we have, please?
Position 7.
We have Marcevics Frazier, case number 22 CR 002-575H. Mr. Frazier, you're accused of criminal trespass and loitering and prowling from April 27, 2022. You have the right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Zach Finley. And with regards to this case, this is going to be a negotiated plea. So, Mr. Frazier, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. All right. This is going to be a negotiated plea. Ms. Sowry, what's the recommendation?
Yes, Your Honor. I just want to state that this defendant is also on the add-on calendar, positions 3 and 4.
I don't see an announcement for position 3 and 4. What are we doing, Mr. Finley?
I did not receive him in the add-on. I
And
did
with
not
those,
see the offer.
with those positions, the offer is only 12 months to serve. It's a criminal trespass in both cases, and they're regarding the same location that he's here for on this current charge. I actually found out he had these 2 cases, or 1 case, and then I had to file another one. So the offer for 3 and 4 is 12 months to serve.
Okay. Mr. Finley, do you want to confer with your client?
Yes, I do, Judge.
All
Yes,
right.
please.
Will the host please place 4 North and Zach Finley in a breakout room, please? 4 North, do you have additional cases there?
Yes, I have Cole, position 5 as well.
Okay, those are all Mr. Finley's clients as well. So,
So,
go
yeah.
ahead and put a breakout room with 4 North and Zach Finley. If the host could please place them in a breakout room. Okay, and meanwhile, while we're doing that, Mr. Coleman, you will keep track of the cases that we are doing so far.
I will.
All right, I have a bench warrant set aside for Zakaria Humadi. Is Zakaria Humadi present? Just wondered. He or she doesn't have to be present until 11 o'clock. So we still have a half an hour out on that one. Okay. All right, on the add-on calendar that I have, we have position 1 that was a plea, position 2 was a plea, and position 3 and 4 are pending. On the regular all-purpose calendar, position 1 was a plea, position 2 was a plea, position 3 is a reset to May 26. Position 4 is supposed to be a plea, Sam Carson. So I don't know whether we are addressing him today. So that's still on hold. Position 5, Adrian Cole is not addressed yet. And it looks like it's supposed to be an arraignment and a bond hearing. So we're still waiting on that. Position 6, Whitney Craig is also waiting on announcement from Mr. Finley. Position 7, Marcevix Frazier is who we are addressing right now. Position 8, Mark Gores is also holding for announcement. Position 9, Willie Grace, we are also holding for announcement. Position 10, this was an arraignment and further notice for trial, bond modification denied. Position 11 was a plea. Position 12, okay, 12, 13, 14, and 15. The defendant is James Sidney, and he's on a loan out to Cobb County. So his cases are reset to May 17.
Judge, they're going to be reset to the 19th.
To the 19th, okay.
Yes, ma'am.
James Sidney will be reset to May 19th. Position 16 was released. Position 17 was a plea. Position 18 was a plea. Position 19 is also in Cobb County. Are we resetting it to May 19th? Let's put down May 19th in case they come back from Cobb, okay? For position 19. For position 20, Merritt was a plea. 21 was a plea. 22 is going to be a MH reset. Mr. Coleman, do you know what date it's going to be reset to?
I don't know if he's going to need to have a psych eval done. I emailed my social worker yesterday, so she should go out to the jail to see him hopefully by tomorrow. I would reset him to maybe next Thursday, the 19th.
All right, we'll reset him to May 19th. Do you want to put it on the competency calendar?
Not at this point. Again, I don't know exactly what his condition is because I was not able to see him yesterday. When I went to the jail, he refused to come out to see me, so I can't really assess what his condition is.
May 19th it is, okay? Position 23 is arraigned and further notice for trial. Same announcement for 24, Christopher Reed. So Mr. Coleman, is Mr. Reed asking the PD's office to withdraw and him getting a private attorney?
Well, I don't think we were formally appointed to his case. Speaking to him, he says that he had a private attorney who I think suffered a heart attack, some type of medical situation where he was no longer able to represent Mr. Reed.
My goodness, okay. All right, well, y'all have been representing him since initial appearance, so technically speaking, the court considers y'all on record as the attorney, so
Yeah, and he told me
unless
again
y'all
that
file a
he had,
withdrawal.
yeah, he says that he had a private attorney, I guess before he picked up. It looks like he's in jail now off of a warrant. He says that neither he nor his counsel received notice of the court date. So I guess he had private counsel before he was in jail.
Well, you know the court's position on that. So 25, Sanders is arraigned and further notice. 26, Antoine Smith is 25 and 26. 25 took a plea. What's going on with Antoine Smith?
No, 25 was actually reset jail jury, and it should be the same for 26 as well.
I've not taken a plea. I've not addressed either one of them. So are you filing waiver of arraignment?
1 second. Yeah. They will be brought out for arraignment. I think that we did 25 already.
And we did do 25.
Oh, okay, 25.
Yeah, 26.
Okay, he was arraigned and
brought
further
out for
notice.
arraignment, and it's going to be reset.
So 26. 26. Are you filing a waiver? Uh-oh, we lost him. Okay. All right, we stopped at position 26, so we'll get back to that. All right, Mr. Findling, we're going back to your client, Mr. Frazier. What's the announcement?
Yes, Judge. We're going to move forward with just an arraignment on each of his cases.
Okay, all right. So that was position 7.
7, and then
3
the
and
2
4.
add-ons. Yeah.
Okay. And do you waive the reading of the accusations for all 3 cases?
I do, Judge.
All right, thank you. Mr. Marcevics, Frazier, as far as we can tell right now, you have 3 open pending cases in the state court of Fulton County in which you've been accused of misdemeanor offenses. The first one I'm going to list is 22 CR 002-575H, in which you're accused of criminal trespass and loitering and prowling from April 27, 2022, and the Fulton County Solicitor General's office has filed accusations with regards to those 2 charges. With regards to the second case, that's 22 CR 002-864H, State versus Marcevics Frazier. You're accused of criminal trespass from February 14, 2022, and an accusation has also been filed with regards to that case. And the third case is 22 CR 00117H, State versus Marcevics, Tolly McCoy Frazier, accused of criminal trespass from March 1st, 2022. And this case has also been so accused. You have been advised of your right to remain silent, and you do have counsel representing you, Zach Findling from the Public Defender's Office. These 3 cases represent misdemeanor charges to which you are legally presumed innocent until the case goes to trial. Upon your entry of a not guilty plea to all the charges in these 3 cases, the cases would then be put on track for a trial before a judge or a jury. At the time of the trial, the prosecutor, the Fulton County Solicitor General's office, has the complete burden to prove the charges against you beyond a reasonable doubt. If the prosecution does prevail, you could be convicted of one or more of these charges in one or more of these cases, and your penalty could be up to $1,000 fine and or up to a year in prison for each convicted offense. Given this information, how do you plead to all 3 cases?
Not guilty.
Repeat, please.
Not guilty.
All right, I'll accept your not guilty plea to all 3 cases, and they have all 3 been arraigned and further notice for trial. Mr. Findling, this will be a bench or jury trial?
A jury trial, Judge.
All right, thank you. Anything else to address?
Nothing further. Thank you, Judge.
All right, thank you.
Oh,
Okay, we lost Mr. Coleman for a minute. 4 North, who's your next case?
I'm sorry, did they say position 5?
your position 5.
Okay.
Good morning.
Good morning, good morning. I'm sorry, sir. I'm just trying to get my paperwork together. There we go. All right. Mr. Adrian Cole. Oh, I lost you. The screen is only showing your ear. All right. Whoever is at 4 North, can we adjust the screen so that Mr. Cole's face is in? And if Mr. Cole, if you could move a little bit to your right, I think. Perfect. Thank you. Thank you. All right. So this is State versus Adrian Cole, accused of simple battery domestic violence from April 5th, 2022 in accusation number 22 CR 002-583F. Mr. Cole, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Zach Finling. Mr. Finling, what's the announcement for this case?
Yes, Judge. This is going to be a jail jury bond hearing.
All right. So, Mr. Cole, you have been accused of simple battery domestic violence in an accusation filed by the Solicitor General's Office of Fulton County. Do you waive a reading of the accusation, Mr. Finley?
I do, Judge.
All right. You are legally presumed innocent of this charge, allegedly occurring on April 5th, 2022 in Fulton County, Georgia. And upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, the prosecutor has the complete burden to prove the charge against you beyond a reasonable doubt. If at the time of trial, the state carries its burden of proof, you could be convicted of this offense and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Not guilty.
All right. Your case has been arraigned and is further notice for trial. You may proceed with your bond hearing, Mr. Finley.
All right, thank you, Judge. Yes, we are asking for a bond modification on behalf of Mr. Cole. Mr. Cole, his current bond looks like is a $2,000 cash bond. We are asking for that to be converted into a surety bond. Mr. Cole has held stable employment at Atlanta Peach Movers. He has 2 young kids that he's very active in their lives and helps financially support them, who he misses very much right now. He does have ties to the community. He has tons of family here. Let's see here. Sorry, he has tons of family here. And we are once again asking for that $2,000 modification, Judge. Additionally, he has no interest, obviously, because he can't have communication with Miss Yates through the court, but aside from that, 0 interest in communication with her, so he's not a threat to her in any way. So once again, Judge, just asking for that surety bond.
All right. One of the other requirements is the ankle monitoring services. So part of the bond is that if he does make bond, he would need to be equipped with an ankle monitor and pay for the monitoring services. And that's $299 per month at my last check. I don't know if this changed.
Mr. Cole was potentially, would that be okay?
Yes, ma'am.
Mr. Walker.
Yes, Your Honor. The state is adamantly opposed to any modification. As you're aware, you are the judge that set Mr. Cole's current bond at a $2,000 cash bond and ankle monitor. And the reason you set that bond as such, because the defendant is already out on an aggravated assault with the same victim, 21 CP 203192. He was released on a $15,000 surety bond with a no further contact. I believe that was signed by Judge Oliver in Superior Court. Obviously, he has since violated that no contact order. He has reoffended with the same victim. We have had contact with the victim. She is fearful for her safety, as the state is as well. The defendant also has a hold out of Gwinnett for fugitive from justice. This defendant's past actions have made it clear that he is not going to comply with any orders of the court. He has reoffended with the same victim. The victim is fearful, and we ask that you keep your original ruling that was issued, I believe, September 28th, as it. There has been no changes in circumstances. The victim is still afraid for her safety, and a cash bond is appropriate, and we ask that that bond remain as it, Your Honor.
All right. Bond will be modified to $7,500. That's going to be a surety bond, and he will be equipped with an ankle monitor and he's to stay 500 yards away. The monitoring services, the monitor and the monitoring services will be paid for by the defendant. Any failure to pay will be considered a violation of the bond order and result in immediate revocation. He's to have no further contact with Christina Yates and her immediate family members. He's to stay 500 yards away from 700 Phipps Boulevard in Atlanta, Georgia. He's not to possess any weapons, any firearms, not consume any illegal drugs, and no alcoholic beverages. The ankle monitoring services is something that is provided. The ankle monitoring company normally comes to the jail, and payment would have to be upfront, I believe. So he will not be released from the jail unless he's equipped with the ankle monitor.
Got it. Thank you, Judge.
Thank you. All right, that is on Mr. Cole. All right, 4 South, Courtroom 2, South Annex. Okay, let's just go over some of the cases. Miss Watson Cafe, did you have a case? All right, I still see you walking, so, all right.
I'm sorry. Yeah, I have Miss Kelly Adams. She's on the add-on calendar.
Mr. Coleman just took a plea with her. You might want to get with the public defender's office and just clarify.
When I spoke to Miss Adams yesterday, good morning, she never told me that she had private counsel.
Miss Zakia Watson Cafe is conflict.
For her either.
Miss Zakia Watson Cafe is conflict. All right, both of you need to confer and let me know what I need to do next, okay?
Okay.
All right. Mr. Finley, so we had gone through the calendar right up to position 26. And we have a question about position number 4, Sam Carson. He was not brought forward, so do we know what's going on?
I'm not sure what's going on, Judge. I met with Mr. Carson yesterday and went over this plea offer, so I'm not sure why he's not here. And I also know, looks like I also have Mr.
Yeah, so let's just stay with Sam Carson, position number 4.
Mm-hmm.
All right, I don't know why he was not brought over by the jail, but we'll reset him to May 19.
Okay.
And hopefully we'll be able to address him for the negotiated plea.
Okay.
Now, of course, if you find out from the jail that he was not brought up, you can see if he can be brought earlier to Judge Morrow's SAP calendar on May 17th, but I have a feeling that's pretty packed already.
Okay.
All right. The other alternative is I'm willing to take a plea on Saturday at my C calendar. Just to give you an idea, if you're not doing anything on a Saturday, you know, Ms. Finley?
So I wish it was actually my mom's birthday. It was right before.
Oh, no, then definitely
I'm
not. Okay.
I'm gonna be out and about with my family, but
sing happy birthday, blow out the candles. I've got to take a plea, Mom. Okay.
Yeah, I know. I wish, I obviously want to get them out as soon.
I'm just letting you know because it's a time served plea.
I know.
Okay.
Yeah, I know. I tried to get someone added on to next Tuesdays or earlier, and Miss Grace said it was full.
I'm giving you that option.
Yeah,
so.
no, I know. I wish I could make that.
Okay. Yeah. Position number 5, we is Adrian Cole. We've just arraigned and further notice that for trial. Position 6, Whitney Craig.
Oh yeah, Whitney Craig is going to be a reset. I was told by the jail.
Okay, so reset to May 19.
Yes, please. And then also, not to jump the gun, but position 8, I met with him as well. I'm not sure where Mr. Gores is.
Mark Gores. So that's also going to be a time served plea to be placed on probation.
So he's actually he wanted to plead not guilty too.
Oh, okay, so we're gonna reset him to May 19th for arraignment.
I'm sorry, may I ask the reason for the reset? He's been reset a number of times.
We just need to arraign his case. He's not taking the plea. So he's being, now, on the other hand, Mr. Finling, do you want to file a waiver of arraignment?
I was gonna do a bond for him as well.
Okay,
Yeah, I
so
can just
we'll
address
file
that.
a waiver of arraignment if your case, and then we will reset it to May 19th for bond modification. And the state's
Okay.
on notice that the defense seeks bond modification for Mark Gores.
Okay, so I'll file say it one more time.
Waiver of arraignment, right?
Okay.
And please send that to Melissa Grace at fultoncountyga.gov.
Perfect, will do. Thank you.
All right. So I'm going to make a note that arraignment is waived, and we're going to reset it to May 19th for bond hearing. Position number 9, Willie Grace. What's the announcement?
Willie Grace, that's going to be that was going to be a non-negotiated plea with just jail time at issue. He was, because it has down for him to serve 14 additional days.
Yes, they want him to serve actual 30 days.
Yeah.
Okay, so we'll reset it to May 19th, and that will be credit towards the 30 days.
Okay.
If he decides to take the plea. All right, let me see. I think then we addressed all your other cases already. Position 12 through Sydney James is reset to May 19th, pending his return from Cobb. Position 16 is released. Position 17 was a negotiated plea, 18 was a plea. Then we move on to Mr. Coleman's cases. Mr. Coleman, are you back with us? Daryl Coleman, are you back with us? I see Daryl Coleman on the screen. Mr. Coleman? All right, so Mr. Findling, if you can take notes of Mr. Coleman's cases.
Yes, I will.
We last left off with finding out the status of his cases. I'm going to start with 25. Sanders was arraigned and further notice for trial. 26. Antoine Smith is also supposed to be arraigned and further notice for trial, but he was not brought over. So please ask Mr. Coleman, if he can hear me, to file a waiver of arraignment.
Okay.
All right, for position 26, Antoine Smith. And Ms. Grace, we will make note that this is a waiver of arraignment and the case is further notice for trial. Okay, position 27 is Trappenberg, and he's been also outsourced to Cobb County. So we're going to reset this to May 19th, pending his return from Cobb County. Position 28 was a plea. Position 29 is it's going to be a medical reset.
Oh.
It's going to be 29, 30. Oh, Mr. Coleman, you're back? Good.
Yes, I'm back. We can continue on with going through the calendar, and then I would have an announcement on Ms. Adams.
Okay.
What date are we resetting Mr. Washington to?
Washington. What position number was that? Oh, okay.
29 to 32.
Yeah, put May 19.
May 19, okay.
29, 30, 31, 32 are all May 19, unless you want it longer.
That should be fine.
Okay. Just FYI, position 26, Antoine Smith was never addressed, and you indicated a waiver of, you indicated that this is going to be jail jury.
That's
arraignment.
correct.
So if you
That's
can file a waiver of arraignment, and that case will then be further notice for trial.
Well, actually, no, I wanted him arraigned. So is he available?
No.
I would just waive reading. I wanted arraigned. I would just waive reading and then reset jail jury.
Courts are all now closed.
Oh. I will look and see if I have a waiver form. I'm not exactly sure if I have a waiver form, but I'll look and
Mr.
see.
Finling has one. He can send one to you.
Okay.
All right. So on Antoine Smith, position 26, we will expect a waiver of arraignment. And please,
Okay, and
once
who
you
am
get
I
it,
sending that to?
you're sending it to melissa.grace@fultoncountyga.gov.
Okay, melissa.grace.
Mhm.
And I have one announcement whenever you get a chance, Judge.
Okay, so that was position 26, 27 was reset May 19, 28 is a plea, 29 through 32 reset May 19. 33 Watson is pending a DA transfer. Mr. Walker, Mr. Segura, any news yet on this transfer?
The DA's office did accept this case and sent a transfer order to Ms. Grace about 20 minutes ago.
Yes, I have it, Judge.
All right, thank you. So position 33, Jawad Watson is transferred to Superior Court. 34 is released. So I've got an odd notice here. Position 34 for Carlton Williams is released May 7, 22, and then it says reset further notice, do not bring. So is he released on his own reconnaissance or on his own bond, or is he been transferred to some other location?
I think he bonded out.
Okay.
Yeah, so he's no longer there at the jail.
Okay, and 35 was a plea. All right, that takes care of our SAP calendar. Any questions?
Yeah, actually, I had an announcement. Me and Ms. Watson had an announcement on Kelly Adams.
Yes.
It appears there is a conflict. Ms. Watson was appointed as conflict counsel for Ms. Adams, but that wasn't reflected on the calendar when I got it yesterday, nor did Ms. Adams say anything to me about having other counsel on her case. It appears that the alleged victim on her case, Tony Murray, is also represented by our office. Therefore, we would need to withdraw her plea.
All right, Ms. Sowry, I believe you took the plea, yes?
Sorry, Your Honor, no.
Mr. Segura?
Yes,
Okay.
it's
All right. So
Excuse me, I'm
based
sorry,
on,
Judge, I didn't mean to interrupt. I'm supposed to be pulling Andrew Freeman. Do you guys still need him?
Andrew
Yes.
Freeman, whose
Yes,
client
Your
is
Honor.
that?
I just got a call. I'm sorry to interrupt, but apparently Andrew Freeman was in mental health court. They are sending him to the SAP counter because they want to resolve his cases. I'm not sure if the PDs need to speak with him. I'm sure they will, but I just got the same phone call.
All right, let's go ahead and bring him. I have no idea, but we'll address those cases.
And while they're bringing people, can they look for position? What is it? Position 5?
4.
Because he had a time served, please. So
Yeah,
I mean,
times. Yeah, if we have time position 4.
Francois, we're looking for Adrian, Sam Carson.
And yeah.
Was there anybody else?
What
Position
position is
4,
that?
Sam Carson.
Position 4, you said?
Yeah. Sam Carson, position 5 was arraigned and further notice.
it was position 4.
Yeah.
Yeah.
Was there anyone else, Mr. Finley?
I think we're
That was it for
for the time
Sam
served,
Carson,
yeah.
position 4, and Andrew Freeman.
Mr. Glanton, he was supposed to do that floor, so he didn't bring him? They didn't do him?
We didn't address the Sam Carson.
Let me find out, because that's the mental health floor. Let me see what's going on with him if he's not combative, and then I'll bring him if he's okay.
Okay. And
you know
so
what?
going, so just 1 second. Keely Adams, Mr. Segura, it appears that there was a mix-up with counsel, and she was represented by the wrong office, because she has to be represented by conflict. It appears that the alleged victim, Tony Murray, did you know that Tony Murray was a cross defendant?
I did not know.
Okay, so based on this lack of information, I find that her plea.
He may not have been aware. I have a case number for it. Apparently it is a felony. It's 19 CP 187831.
And I just want to be clear, I don't think that Mr. Murray is a cross defendant. I think he has his own independent case. That
Right.
he's represented on.
Right, but in any event, we're representing him in that case, so we can't represent Ms. Adams.
Correct. I just want to clarify that
Yeah.
he wasn't
Oh, okay.
arrested in connection with this incident.
Thank you. I thought it stemmed from the same incident. So
No,
it's
ma'am.
completely
No, Your
separate
Honor.
incident. Okay, okay. So based on this information, it appears that the plea was not legally correct because she was represented by the wrong office. There may be information that her current counsel, Ms. Zakia Watson Cafe, could have conferred with her. So the plea is withdrawn. And we're going to reset that case to May 19th. And Ms. Zakia Watson Cafe?
Yes, Your Honor.
All right, so I'm sure Mr. Coleman has discussed the plea that she took originally that's now been vacated.
Is someone going to explain to her she's not getting out today?
I have a call set up with her for today.
Okay.
Yeah. Is it possible, actually, Mr. Walker, I'm just gonna call you directly, because, are you the, I'm sorry, are you the attorney on the case, or I'm not sure who to speak to regarding?
The jury is, I don't know if you guys want to take the plea. I don't know if the judge will allow it, but if she still just wants to take the plea she just took to be released, the state is open to that, but we defer to the court, of course, and to counsel.
Yeah, like I said, I had a call set up for her today after this calendar, but I need to speak about what I spoke. I need a conference regarding the plea because I'm concerned about.
Well, I'm still here. I'm still here past 11 o'clock. I still have a couple more calendars to do. So if you can reach out to her and we'll be glad to take it up. If you want me to reinstate the plea, that's fine. It's just a question of signing off on it and counsel not raising objections. Just to let you know that if she's not released today, she's going to be one very, very busy hornet. Okay, so yeah, it's up to you. All right. Okay. At present time, the plea is suspended until Ms. Zakia Watson Cafe lets me know what she wants to do. I think that concludes our SAP calendars. I'm moving on to the DV bench warrant matter.
Yeah, Zach, if you could just forward me a fillable waiver form for me to complete.
Okay.
Thank you.
Yeah, I will. Yeah, no problem.
All right. Zakaria Humadi?
Yes, ma'am. Zachariah.
Zachariah, is it Bumadi? Okay, with a B.
Bumadi, yes.
All right. And my name is Judge Lal, and your case is 22 CR 000720F. And Mr. Bumadi is accused of simple battery domestic violence from February 11th, 2022. The case was so accused at that time. If you just give me a moment, please. Mr. Bumadi, I'd just like to remind you that you have a right to remain silent. Anything you say about the facts of your case, your statements, your statements can and will be used against you in the treatment of your case. You have a right to an attorney. And Mr. Finling, is your office representing Mr. Bumadi? I believe he was represented at initial appearance back on February 14th, 2022.
Judge, I'm gonna need to speak with him. I think I must be getting left off the listserv because I didn't get the additional add-ons and I didn't get this either.
All right. Will the host please place Mr. Bumadi and Mr. Zach Finling in a breakout room?
Thank you.
And while we're waiting for Mr. Finling to discuss the matter with Mr. Bumadi, let me see. All right, we had a second case, State versus Angel Hogg, who was issued a bench warrant on December 7th, 2021, and it appears that he has made a new bond. So he's closed out the warrant with the bond. Oh, Mr. Segura, were you aware of that?
I wasn't. I only had Mr. Bomari.
Okay. All right, so, and then we have our competency calendar, and who will be addressing that today? Okay, also, do we have a David Moultrie? David Moultrie? I have a plea hearing scheduled for today at 11 a.m. for State versus David Moultrie. This is a non-jail plea hearing. Accused of reckless driving. Mr. Segura, are you aware of it? Mr. Walker? My goodness. Counsel is Adam Brown. Okay, let's see now. All right, 3 South, who do we have?
I have position 8.
All right, this is Mr. Mark Gores. Mr. Gores is represented by attorney Zach Finling, who is right now conferring with another client. So 3 South, do you have another case that we can address?
Yes, I have position 26.
All right, let's address position. Mr. Daryl Coleman, are you available?
Yeah, I'm here.
All right, Mr. Coleman, we have position 26.
Yeah, at this time, Your Honor, he would be reset to a jail jury calendar, entering a plea of not guilty. We would ask that he be arraigned. We will waive reading.
Okay. This is State versus Antoine Smith. Mr. Smith, is that your name, Antoine Smith?
Yes, ma'am.
All right, Mr. Smith, my name is Judge Lal, and we are addressing your case 22 CR 002-639F, in which you've been accused of battery against a vulnerable female from April 29th, 2022. You have a right to remain silent. Anything you say about the facts of the case, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Daryl Coleman. You've already had discussions with Attorney Coleman, is that correct?
Yes.
Okay, and I understand that you'll be entering a not guilty plea to this case, is that correct?
Yes.
All right, so Mr. Smith, you have been accused of this misdemeanor offense. The Solicitor General's office has filed that said accusation, and you are presumed innocent of the charge until the case and when the case goes to trial, upon your entry of a not guilty plea, the prosecutor would have the complete burden to prove the charge against you beyond a reasonable doubt. If the prosecutor succeeds, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine. Given this information, how do you plead?
Not guilty.
All right. All right, Mr. Coleman, you will not have to file that waiver. This case is arraigned and further notice for trial. Is there anything else we're addressing?
Yes.
No, that's it. Thank you.
All right, Mr. Smith, Mr. Coleman will be in touch with you, or you can reach out to the Public Defender's Office.
Ma'am, is there a lesser plea I can take if I do go that route?
All right, well, the state would have to give you a plea recommendation and your attorney would have to discuss that with you.
All right.
Mr. Coleman?
Discussed yesterday, Mr. Smith, your other matters need to be resolved first, and then they will present you with an offer. It'll likely be the same offer, but at the time that offer is presented, your felony matter should be resolved, and you would not be facing any additional jail time if they stick to the same offer that they're making today.
All right.
All right, thank you.
All right, thank you, Mr. Smith.
Yes, ma'am. Thank you, ma'am.
All right. 3 South.
Next case, we got position 4.
Okay. 3 South, we are trying to reach Keely Adams, who was at the South Annex. Is there a way you can reach out to Deputy Milton to see if she can have her brought out?
Yes, I can give her a call.
All right, thank you very much.
In front of you, position 4, Carson.
Yes, sir, thank you. Mr. Findling, I know you're discussing with Mr. Bumadi. Are you going to be representing him?
Yes, I will be, Judge.
Okay, we will address Mr. Bumadi very shortly. We just need to take care of our Wright Street cases right now. This is Sam Carson, accused of, this is position 4 on the SAP calendar. And case number is 22 CR 002-617J. Mr. Sam Carson is accused of criminal trespass from April 28, 2022, with regards to a location called the Revival Loft. Mr. Carson, you have a right to remain silent. Anything you say about the facts of your case, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Zach Findling. I'm going to take a pause at this moment. Melissa Grace, we have Adam Brown, who is supposed to be representing our 11 o'clock non-jail plea. He filed a notice of conflict on April 26, 2022. If there's a way you can contact him to find out what's going on with this plea that's scheduled for today at 11 a.m. I appreciate
Your Honor, I'm sorry to interrupt, but I do have an update. I have spoken with someone within our office who is in contact with that attorney, and there is another conflict for today, and they're requesting a reset date.
Okay, that's fine. Okay, so we'll address that. So getting back to Mr. Carson. Okay, so Mr. Carson, for purposes of the plea, may I place you under oath? Raise your right hand if you agree. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? You need to say yes or no.
Yes, ma'am. Yes, ma'am.
All right. Mr. Carson's, he's at 3 South, yes?
Yes, ma'am.
Okay,
Yes,
okay, that's fine, that's fine. 3 South, has the monitor changed? All right, Mr. Carson, can you wave your right hand? Mr. Carson, can you wave your right hand? Okay, I can't see Mr. Carson. I can only see the background. The screen has moved from Mr. Carson's face. I can see someone seated. I can only, Deputy?
Can you see now?
No, sir. They have to move the monitors because you are completely off screen.
Can you see me?
I can see your hand. You're waving your hand.
Can you see?
I can see the defendant.
Okay, now we're good. I have no idea. It just like sunny change. Okay, now I can see him. Can you see him, Mr. Walker?
I can see the defendant, Your Honor.
Could you see him at all times?
Yes, ma'am.
Okay, I don't know what happened, but all right. So now I can see him also. Okay. So let's proceed with the plea. What's the plea, Mr. Walker?
It is time served, credit for 13 days, balance suspended with the stay away from Revival Lofts located on 159 Ralph McGill Boulevard here in Atlanta, Georgia, 30308.
All right. Mr. Findling?
Yes, Your Honor. That is our understanding of the recommendation, of which we do agree, and additionally stipulate for the venue, factual basis, and ID.
Thank you. Mr. Carson, have you consumed any medication or alcohol recently?
I consume my medication for what's it called? Some people, but
So you consumed some medication recently?
for here for
All
the
right.
jail side.
Okay,
Yeah.
now, even after taking that medicine, are you able to understand the proceedings?
Yes, ma'am.
Are you able to understand me?
Yes,
All right. And are you able to understand your attorney?
yes,
Are you satisfied with his representation?
yes.
And is anyone forcing you to take a plea today?
No.
If you decide to take this plea, you would have to give up your right to go back to court, to have a trial in front of a judge or a jury, to be able to have your attorney assist you, to confront your accuser, examine witnesses, challenge the state's evidence, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes,
How do you plead to one count of criminal trespass?
guilty.
Your sentence is 12 months to serve 26 days, credit for time served, 13 days. Your time at the jail is concluded. If you have no other holds at the jail, you will be released within 24 hours. The balance of the time is suspended, but you have to stay 200 yards away from the building called the Revival Lofts at 159 Ralph McGill Boulevard in Atlanta, Georgia. If you return to that location, you will be arrested and charged again with criminal trespass. Do you understand, sir?
Yes.
Do you have
Yes.
any questions about your bond, about your plea?
None. No question.
Thank you. That concludes the case.
The police dead.
All right. Next.
Wait,
Yeah.
can I say, can I do this next one? This next guy, Mr. Freeman, real quick?
Mr. Walker, do you want to address Freeman right now or?
So,
after
I mean, I would be glad to provide the court with the limited information that I have. He has in total 3 open cases. The first one is 21 CR 002426B.
I'm sorry, you're gonna have to slow down, sir.
I'm
Okay,
sorry.
because he's not on the
21
calendar. Okay, 21 CR 00.
2426B.
Okay,
Second one is 21 CR 003858B. Third one is 22 CR 001579B.
all right, just pause for a second. This
the
is
last-
Andrew Freeman, right? All right, Mr. Freeman, we're going to be addressing the 3 cases that Prosecutor Walker has just identified. Please remember that you have a right to remain silent. Do not say anything about the facts of your case. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. All right, Mr. Finling, are you familiar with this case or the cases?
I'm not, Judge. I mean, I just spoke with Derek, and we're want to reset this so we have time to review the facts, the discovery, kind of weigh what would be best for Mr. Freeman.
The state concurs. It's not a time served offer anyway, so it's probably in the best interest of all parties for a reset.
And I know there's limited information on both sides for these cases. How far out do you want me to reset these cases?
The state is comfortable for 1 week. I really defer to counsel though.
Yeah, if we could do, next week would be.
All right. Miss Melissa Grace, these are the 3 case numbers that were identified by Mr. Walker. Did you get to write them down?
Yes, Judge, but Mr. Jordan was gonna handle it, so we're good so far on whatever they decide.
I got it.
Thank you, Ms. Jordan. Okay, Mr. Andrew Freeman, you have 3 open cases at the Fulton County State Court. The Public Defender's Office is going to send an attorney to discuss these cases with you and to let you know what your options are. We're going to address all 3 cases at the May 19th, 2022 calendar. Today is May 12th. All right? And by that time, you should get more information about your cases, your legal options, and what your next step should be. Understood?
Yes, ma'am.
All right. Thank you, Mr. Freeman. This concludes your 3 cases. All right. 3 South, who do we have? 3 South.
Got Grace.
Grace. That would be position number 9, Willie Grace, okay? This is State versus Willie Grace, case number 22 CR 002578D. Mr. Grace is accused of 3 counts of simple battery, 1 count of disorderly conduct, and 1 count of obstruction of a law enforcement officer. This stems from an April 27, 2022 incident. And Mr. Grace, you have a right to remain silent about the facts of your case. Anything you say about the alleged facts, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Zach Finley. This is going to be a non-negotiated plea hearing, which means that the prosecutor is going to articulate the recommendation for if Mr. Grace decides to plead guilty to the charges. And then the defense is going to give me an alternative recommendation. I'm going to consider the recommendation, the alleged facts of the case, and his criminal record history before I make a decision as to which recommendation I will accept. I will let Mr. Grace and his counsel know which recommendation I'm accepting, and then they can decide whether they want to proceed with a plea or whether they would like the case arraigned and further notice for trial. Ms. Sowry?
Yes, Your Honor. Briefly, the facts of this case is that officers responded to the Ponce City Market regarding a dispute. Upon arrival, the officer spoke with the security officer who stated the defendant had been in the market harassing people for money, punching and pushing women unprovoked. The victims did not sustain injuries. However, we do have video of the attacks. Your Honor, this defendant is a repeat offender. He has multiple convictions for crimes against persons and is a danger and nuisance to this community. He presents a risk of reoffending, and he's been arrested and convicted at least 4 years straight for criminal trespass, simple battery, simple assault, and criminal damage to property. I do want to put on the record, he does have FTAs in his history as well as a guilty conviction for public indecency. So, Your Honor, the state is recommending that the defendant serve all 30 days. Regarding this plea, it's 12 months to serve 30 days. Credit for time served 16 days and the balance suspended. No contact with the victims, Yandon, Barla, Stephanie Rogers, Janae Vernon, and stay away from the Ponce City Market located at 675 Ponce de Leon Avenue in Atlanta. Nothing further.
Thank you. Mr. Finley?
Yes, Judge Law. I am asking for time served on behalf of Mr. Grace. He has served 16 days now and is being asked to serve 30 days, so 14 additional. While meeting with Mr. Grace, we discussed with him obviously the seriousness of these charges and how to act in public spaces. He understood. We talked for a while, and once again, Judge, I am asking for the time served.
What is the basis for just time served? I don't understand. Let's hear his criminal history record.
Yeah.
Ms. Harrison? This is position number 9 on the SAP calendar.
Yes, Judge, he has 57 cycles.
I think that says it all. Thank you.
Okay.
And Your Honor, I would like to reiterate most of those cycles, at least the last 5 years, he has multiple criminal trespass, obstruction, disorderly conduct, simple battery, terroristic threats, simple assault. He has multiple convictions regarding crimes against persons, and they're similar to the offense that he's here before you today for.
Thank you. All right. Mr. Grace is a gentleman who is over 50 years old. He's had a significant, grossly significant criminal record history, in which his interactions with members of the public have not been very pleasant. His arrest record has so reflected that. I'm just surprised by the rather generous plea offer that the state's offering with regards to this case. So you can definitely see I'm clearly recommending that Mr. Gray serve actual 30 days at the Fulton County Jail, and that he understands that he needs to stay away from the Pond City Market, at least 200 yards away, and never enter those premises. That is my recommendation. In addition to him attending a MHET as well as an ADET, and that he will be reporting to probation every month. I will waive his probation fees, but he will be reporting to probation every month. He'll be subject to random screens. That is the recommendation that I'm willing to accept. Mr. Finling, is this something that your client wants to pursue, or we can arraign the case and have it set for trial?
Mr. Grace, I know we originally talked about the no probation. The judge is asking for there to be probation. Would you agree to that, sir?
Right. So what?
Sorry?
What'd you say?
Mr. Grace, can you hear me?
Yes, I can.
Mr. Grace, if you want to plead guilty, you have to serve 14 more days at the jail.
Okay, yeah. Yeah, okay, I'll do that.
No, listen.
That,
listen.
Yeah.
And then you will be on probation. You have to report every month for probation for the next 11 months.
Okay.
And you must stay 200 yards away from the Pond City Market.
Yes, ma'am. So I gotta serve 14 days?
You have 14 more days.
Okay.
And you cannot return to the Pond City Market.
Okay, yes, ma'am.
And you have to take a, I'm sorry, no, I don't believe the evaluation was called for. So that's off the table. And he has to have no contact with the alleged victims that he dealt with at the Pond City Market.
Yes, ma'am.
All right, Mr. Finling, what do you think?
If Mr. Grace agrees, then we can move forward, Judge. Sound like he agreed, yeah.
And do you stipulate to the venue and ID?
I do, Judge.
Okay, so this will be a non-negotiated plea. Mr. Grace, if you please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Mr. Grace, you've been accused of 3 counts of simple battery, disorderly conduct, and obstruction of a law enforcement officer at the Pond City Market in Atlanta, Georgia on April 27, 2022. If you decide to accept this plea offer, you would be placed on, you have to serve 14 more days and then be placed on active probation for the next 11 months. Do you accept these arrangements?
Yes, ma'am.
Have you consumed any kind of medication or alcohol recently?
No, ma'am.
Have you understood the proceedings so far?
Yes, ma'am.
Have you understood your attorney, and are you satisfied with his representation?
Yes, ma'am.
Is anyone forcing you to take a plea today?
No, ma'am.
And are you entering a plea of guilty to these charges freely, voluntarily?
Yes, ma'am. Yes, ma'am.
And knowingly?
Yes, ma'am.
If you decide to enter a plea today, you would have to give up your constitutional rights to go back to court, to have a trial before a judge or a jury, to have the assistance of counsel to challenge the charges brought against you, to confront your accuser, examine and cross-examine witnesses, to be able to challenge the state's evidence, argue your case to a judge or a jury, and have the state try to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 3 counts of simple battery?
Guilty, ma'am.
How do you plead to 1 count of obstruction of an officer?
Guilty.
And how do you plead to 1 count of disorderly conduct?
Guilty.
Your sentence is going to be 12 months to serve 30 actual days. No credit given for halftime, no reductions made from the 30 actual days. You'll be given credit for the 16 days that you've actually served. So which means you have 14 whole days to serve at the Fulton County Jail.
Yes,
After you've completed the 14 days, your balance will be the balance will be placed on probation. You will report to probation every month. Your probation fees shall be waived. Your first report date is going to be on Tuesday, May 17th, before 5 p.m. at 132 Mitchell Street. If you do not report to probation at that date before 5 o'clock, your probation will be revoked and you'll be brought back to jail to serve out the rest of the 12 months. Do you understand?
Yes, ma'am.
At all times, you are to stay away from Ponce City Market at 675 Ponce de Leon Avenue in Atlanta, Georgia. And you are to have no contact with Yondon Barella, Stephanie Rogers, and Janae Vernon.
Yes, ma'am.
That concludes this case. Thank you.
14 days, sir, ma'am? 14 days?
Yes.
14 more days.
14 more days. Now go home.
And then after that, what do you do?
Go home.
Go home and then go back to probation on Tuesday.
Yes, yes, ma'am. Thank you, ma'am.
Mr. Grace,
Yeah.
is this Shannon Court address? Is that still the best
Yes,
one?
yes,
No,
yes,
no.
Shannon Court.
Thank you, sir.
Yeah, you're welcome.
All right. Position number 9 is a plea, so it's not reset to May 19th anymore. 3 South, we have another case that's represented. Yeah. This is Mark Gores, Mr. Finley.
Yes, ma'am.
All right, and I understand this is going to be an arraignment, correct?
That's correct.
And a
Judge.
bond hearing.
And Your Honor, I'm requesting a breakout for this case.
Right, very briefly, would the host please place Mr. Finling, Ms. Sari, Mr. Walker, and myself in a breakout. Mr. Gores will be with you very shortly.
Me as well, Judge, if you don't mind. Thank you.
Did you say $2,500 bond that you're recommending?
Excuse me, Your Honor.
Yes, Deputy Milton?
I was told that you needed Kelly Adams, but you.
Keely Adams, yes. Please,
I was
thank
told
you.
that you need her again.
Yes, her attorney would need to have her back in the courtroom. Thank you.
Okay, we'll make it.
Thank you. I appreciate it. Thank you so much.
Mhm.
Mr. Mark Gores, sir. My name is Judge Law, and we are addressing your case. You've already had conversations with Attorney Zach Finley. And based on the sidebar conference I've had with your attorney as well as the prosecutor, your case is going to be reset to May 19th. They're going to evaluate your case for further options, and Mr. Finley will be in touch with you to discuss those options that they can have for your case. So we're going to reset the case to May 19th at 9 a.m. Understood, sir?
What's that?
Your case is going to be reset to May 19, 2022. I've already had a conversation with your attorney, Mr. Zach Finley, and they want to evaluate your case and consider other options that may be favorable to you. So he will be in touch with you to discuss these options, and we will address them on May 19, 2022 at 9 a.m.
Well, the charges don't coincide together with where I was.
Mr. Gores,
Yes.
I would strongly advise you not to speak to the facts of the case that could be used against you, sir.
Yeah. So just to remind you, you have a right to remain silent. Anything you say about the facts or the case, your statements can and will be used against you. You are represented by counsel, Mr. Zach Finley, and he will be discussing this case. And if you have any issues about the charges or the allegations, please address that with him in confidence so you do not incriminate yourself.
Will you come see me, Zach?
Repeat?
Will you come see me as soon as possible?
Yes, sir. Yes, sir. I'm going to come visit you before your next court date. Yes, sir.
Thank you. That concludes the case with Mr. Mark Gores. This case is reset to May 19, pending a possible evaluation. Okay, getting back to, well, we're waiting on Ms. Keely Adams. Let's address Mr. Boumadi. Mr. Boumadi, I know you've been very patient.
Yes.
Okay. Mr. Boumadi, you've already been advised of your right to remain silent. Your attorney is Mr. Finley, and this is your request to set aside the bench warrant that was issued against you for failure to appear in court. Please proceed, Mr. Finley.
Yes, Judge. We are asking the court to set aside this bench warrant. He is a student at Georgia State University in business, pursuing his bachelor's degree. He, right now, obviously it is summer, he's at a Streamside Drive address. He originally had supposedly a notice sent to his Georgia State housing, but he never got notice. So he never received that, and unequivocally, he's a young man pursuing his bachelor's degree, trying to, build upon his life, and he definitely unequivocally would have been at court. Also, for this hearing, I know he got notice and a link 30 minutes before this court date. So he did. I do have a new address for him where he is during the summer. Yeah, I mean, he just unequivocally would have been there if he would have gotten notice, Judge.
Well, we've only had a Piedmont Avenue address at all times. That's the address we've had since he was in jail on February 14th. And he's required by law to update the court with his current mailing address.
But his address, when he originally missed court, Judge, he was at that address. That's his Georgia State housing address, but he says he never received notice there, and he does actively check his mail. And he says he did not receive notice, Judge.
Well, we don't have a return to sender, so, and it's a 175 Piedmont, but there's no unit number or apartment number indicated. So that's possible that it just went lost, because was he in an apartment or unit number?
If I may, it's all the mail goes into a mail room, and they send out emails to the students to mail, And I check my email very often, and I just never got anything. Even at the end of the year.
Well, Mr. Boumadi, since you're the accused, you're responsible for making sure the notices get to you, and we can only work off whatever information you give us. Any
Judge, I
issues
think
with
he
you
got
receiving mail,
lost.
that's entirely up to you. And the reason I'm going on about this is because I need you to stress to you that you're a college student with a criminal case against you, and you need to get this resolved so you don't damage your future. Understood?
Judge, unfortunately, I think he went out about 30 seconds ago. I think he probably missed
Yeah,
one
well,
word.
he didn't hear the diatribe from me.
I know.
So, all right, Mr. Segura, any strong feelings about this?
Actually, before this, the victim was also arrested for battery against this defendant on the same date. I want to make confirmation that the defense attorney is an individual named Mide Oralore. Is the PD know who this individual is, or is he also connected with the office?
We have the, was this a cross defendant, Shamar Mintz, Mintze?
Yes, and his case is 22 CR 000715H.
Yeah, let's make sure we don't have a conflict issue here.
Oh, no, mine says at banshee.law.com.
Looks like Mr. Mintz filed a waiver of arraignment, and Mr. Mintz is represented by private counsel Ola Lowe. Who's from Newnan, Georgia. So he's got private counsel.
Okay.
And he's filed a waiver of arraignment, so. All right, so like I said, Mr. Segura, any issue with the bench warrant being set aside?
I want to emphasize that he did have an address and also an active phone number and email address. And it should have been his responsibility to actually notify the court and check his mail, especially considering he had a case of battery going against him. And that.
Right.
I'm sorry to cut in, Your Honor. The state will consent to the set aside. We just ask that the address is up to date on Odyssey, so we won't have any issues going forward.
Agree. And also a decision as to whether he wants to arraign the case today.
Yeah, I mean, it's up to counsel.
I would, if we could do that at a later date, I would like to, address, the facts of the case.
Well, the state would like to get the case arraigned. I mean, if he's here.
Okay, yeah.
He missed arraignment. That's why I'm
Okay.
asking for arraignment.
Yes, Judge.
All right.
Then arraign it. Yeah.
Okay. Mr. Boumadi, what that means is that you will be entering a not guilty plea and have the case scheduled for trial before the division judge. And that would be, actually, does that case need to go to Division H? Because right now it's in Division F.
Whoever has the lowest case number, I'm not.
This one is 720. Yeah, it would have to go to Division H. All right. All right. So that's something the litigation managers will take care of. Mr. Boumadi's case has to be transferred out of Judge Richardson's division to Division H. And Mr. Boumadi, you're represented by the Public Defender's Office presently. If I'm assuming that they financially qualified you, so Mr. Findling, is your office going to continue representing him?
Assuming so, I'd have to look into, as I just got
Right.
alerted about this case.
Okay.
An hour
So
ago.
Mr. Boumadi, if you can unmute, please.
Hi.
All right. I'm going to grant the request to set aside the bench warrant, so there's going to be no arrest warrant pending against you. But this is conditioned upon you providing us with your current mailing address, complete mailing address with apartment numbers, unit numbers, and whatnots at all times. If you change your address, you are responsible for making sure we have the right address. And if there's an issue with the receipt of mail because of some email issue or something like that, that's all on you, okay? You are charged with simple battery and you have a companion case, 22 CR 0007158, that's now also on the trial track. So you had missed your court date in which you were either given the option of taking a plea or entering a not guilty plea and having your case scheduled for jury trial as well. Based on the information I have, I understand that you will be entering a not guilty plea and have your case scheduled for trial. In the future, especially when you have your next court date, the option of possibly taking a plea or resolving your case is still open. Do you understand?
Yes, ma'am.
All right. You might also want to talk to the public defender's office to see if your case may be eligible for pretrial diversion. But that's something that is out of my hands. That's entirely a decision between your attorney and the prosecutor. But in the meantime, you have been accused of simple battery domestic violence on February 11th, 2022, allegedly in Fulton County, Georgia. Upon your entry of a not guilty plea, the case will be scheduled for trial. At the time of the trial, the state would have the complete burden to prove the charge against you beyond a reasonable doubt. If the state prevails, you could be convicted and face a penalty of up to a year in prison and or up to $1,000 fine for this offense. Given this information, how do you plead?
Can I talk to my public defender? Is that an option?
Yeah.
Yes, Mr. Jordan, please place Mr. Boumadi in a breakout with Mr. Finley. All right, and then Mr. Finley will get back to you after I finish with South Annex. Miss Watson Cafe, are you present, please? Miss Zakia Watson Cafe.
Judge, I'm here.
All right.
All right.
All right, let's unmute.
All right, let's unmute.
All right. We, South Annex, if we could unmute Deputy Milton. All right. We are readdressing the case of State versus Keely Adams. Miss Adams, can you see me?
No, I cannot.
Okay, if you'd like to
You're
come.
on.
Yes.
I have it on the other, no, sit down there for me, please. Okay, no, she can see you.
All right.
Yes, she
And
can.
Miss Adams, we have your attorney, Zakia Watson Cafe, on the screen. Do you see her?
No, she's here. She can see you. Your attorney can see
I
you.
cannot see her.
Yeah, but they can see you. I promise you.
She asked me if I could see her.
Okay.
I said no. Would you mind stopping interrupting me?
Thank
Your
you,
Honor.
Miss Adams. Thank you. Thank you. Miss Watson Cafe, as you can tell, we were originally addressing a plea under the misconception that the Public Defender's Office had the right to represent her. How would you like to proceed?
We can move forward with the.
Is back pay for Social Security, ma'am. Back pay. I'm not checked. I have not cashed my check yet. I'm waiting to get my own place.
All right.
So, is it possible for me to do it? I just want to make sure that she still wants. I'm assuming that she still wants to move forward with the plea that she spoke to Mr. Coleman about. Same terms. I spoke to Mr. Walker about it, so it would be the same terms. We would be objecting to the restitution, but other than that, I just want to make sure that she would still want to move forward. I can't imagine anything changed, but.
All right. Now, the restitution of up to $4,000 was based strictly on her outburst. So that's entirely up to her.
Back pay for Social Security.
Okay.
I got,
So,
driver's
Mr. Jordan,
license.
if you could please place Miss South Annex and Miss Watson Cafe in a breakout room, please. Thank you. All right. Going back to Mr. Boumadi, Zakaria Boumadi. Mr. Boumadi, if you can unmute, please. Given the information I have provided with regards to arraigning the case, how do you plead?
I plead not guilty, ma'am.
All right. Your case, the bench warrant is going to be set aside. You are responsible for making sure we have your current mailing address. Your case is going to be hopefully transferred to the appropriate division, and your case is arraigned and further notice for trial. Please make sure you comply with the conditions of your bond. Mr. Finley, anything else?
Nothing else, Judge. I did give him the phone number to make sure he sets up an appointment application with the public defender.
All right. Mr. Finley, please submit your proposed order to Miss Melissa Grace, and we will make sure it's placed and that the warrant set aside, as well as the arraignment, and to make sure the case is with the appropriate division judge. Thank you.
Ma'am, I have a question actually. Where would I go to set up my information or to like update it?
You go to 160 Prior Street. That is the
Yeah, okay, so I just go there in person and just go from there.
It's on the
Okay.
first floor, the clerk's office.
Sorry to cut in, but can you put it in the chat and we can just have Miss Grace updated?
No, I want him to come down.
Okay, I'm sorry.
All right, so he'll know where to go whenever he changes his address. Thank
So
you.
there's no way to do it online?
No, you're gonna come down, sir. You can come out of your room, wear your mask, come down to the courtroom, come run to the
Okay.
courthouse. All right, you didn't do it the first time, we're gonna make you do it now. Okay. All right, that concludes Mr. Bomadi's case. We have Ms. Keely Adams. Do we have anything else before I go in a breakout for my other calendar?
I didn't get the disposition on position 16, position 6, I'm sorry. Whitney Craig.
That's reset to May 19th.
Okay. All right, that's all I needed. Thank you.
All right. Okay, Mr. Howe, okay, I'm going to be addressing my next calendar, which is always done in breakout. Mr. Jordan, what's the status? Is Ms. Zakia Watson still discussing the matter with Ms. Keely Adams?
It's Miss Champion, Judge. Yes,
Miss
they're still
Champion.
they're
All
still
right.
in the breakout room.
Okay, can you do this? I'm going to go into a breakout with Mr. Howard, Mr. Walker, and who else do we bring in? Mr. Howard?
Nakasha.
Nakasha?
Yes.
Okay.
Do I see her on the screen? Oh, Kasha, okay,
Yes.
all right, hey Kasha, all right. So it'll be Kasha, Ian Walker, Derek Howard, myself in a breakout room. And Ms. Champion, if Ms. Watson Cafe comes back out with Keely Adams, please call me and I need to just step out to address that, okay?
Okay then. Okay, Judge.
Thank you, please monitor that, thank you.
Excuse me?
Hey, what's up, man?
Hey, so do I just leave or?
Yeah. No, so you're good to go. And
Okay.
I'll just get over there and change your address just as soon as possible.
All right, and for the next court appointment that I appoint, like I set up the appointment, right?
What's that?
Like court hearing.
Do you set up your appointment for court?
Yeah, with the phone number you gave me. Is that it?
Oh, no, that's for the public defender's office. Just contact
Oh.
them and ask how it works with submitting an application for a public defender. Okay?
Okay. Do I have to do that?
Yes. Yeah, you have to do.
Also, can you just remind him he's continuing on pretrial?
You hear that? So you, Mr. Bowman, you're continuing on pretrial, Mr. Bumani.
All right. And okay. When will I know when my next court hearing is?
Miss Beverly, do you know by chance?
His next court notice will be mailed out to him.
Okay, so it'll be mailed out to the address, but you got to make sure to change to the stream side. Okay.
So I can't leave the country then, right? Because I was actually going to leave to Morocco, where my parents are from, because something happened, a family tragedy. But am I just not able to go?
I'm not 100% sure.
All right.
Miss Bev, do you know?
You would have to get the bond order amended because he is a pretrial client, and if he leaves, he would be in violation of those conditions.
Okay. So. Okay.
Well, okay, thank you.
So your pretrial order would need to be amended. I'll have to figure out how to do that. When is that trip?
I was going to leave on the 18th.
Okay. All right, I'm gonna talk to my supervisor and we'll figure out how to do that. Okay.
All right, thank you. Should I stay in the meeting?
Okay, so yeah, hey, hold on one second. Okay, will you hold on? Because I want to make sure I'm not familiar with that. I've never done that, and I want to make sure that you're kind of safe. So let me talk to my supervisor. Okay.
Okay.
All right, Ms. Watson Cafe, I am back and to address Ms. Keely Adams. What is the status? I'm sorry, could you unmute, please?
I'm sorry, Your Honor.
It's all right.
She does want to move forward with the plea.
All right, so in light of the fact that conflict doesn't have any objection to the PD's taking the plea on your behalf, we're going to leave the plea as it is in place and move forward with her reporting to probation onwards.
Oh, is it possible that we can address the restitution? I understand, Your Honor, that it was based on a statement, but there was a misunderstanding by Ms. Adams. That what was stated was her total assets. That's not an act. She doesn't have $4,000 to pay toward restitution. That's my understanding. Also, Your Honor, the fact that she's still in custody is indicative of that. Her bond is $1,000, and so she wouldn't be sitting there. She had the financial wherewithal to bond out. So she's just. I hate to. I at least want to put my objection. I know Mr. Coleman had an objection, or that's my understanding, speaking to Mr. Walker about the restitution, if any, but she just does not have the financial wherewithal to pay up to $4,000 or anywhere close to that.
Mr. Segura, any objection to removing the restitution requirement in light of the fact that the alleged victim has got other fish to fry?
I think for alleged victim, I'm uncertain how much the damage is. I'm guessing since the public counsel is representing him, they might have a better idea as to what the damage is. And if it's extreme, Probably not, but it's light, probably so.
I'm sorry, I didn't understand. So is that a yes or a no? Any objection? No, no objection. Or do you have no comment on that matter?
No comment.
All right. I understand that Ms. Adams did make that grandiose statement that she's willing to pay up to $4,000 as some kind of sign of bravado. And based on that, I'm going to remove the restitution requirement. If the alleged victim has any damages, they are free to pursue that in a separate civil action. So I'm going to remove the restitution requirement and also counsel Ms. Adams to next time be very careful what she says in open court. She could just inadvertently step into it. So that concludes this case. Thank you.
Thank you, Your Honor. May I be excused?
Yes, thank you, Ms. Watson Cafe. I appreciate you appearing.
Thank
Thank you. Take care. Be safe. All right.
Bye,
All
Your
right,
Honor.
Deputy Milton, that concludes our case with Ms. Keely Adams. Thank you so much for bringing her out. I appreciate it.
You're welcome.
Thank you.
All
Bye.
right. Bye-bye. Thank you. All right, folks, I believe we've already concluded with the calendar. We are only dealing with the competency calendar, and I'm going to return to the breakout room. Anyone who doesn't have any other business with the court, you are free to go. And thank you. And please make sure if you have any documents, please submit them to Miss Melissa Grace as soon as possible. Thank you.
Thank you, Judge.
Thank you. Have a
Thank you,
good rest
Judge.
of the day.
Thank you.
Melissa, you can go back into the breakout room.
April, how do I do it? I was just about to call you. Yes.
Okay, go ahead. Oh, Lord. Okay.
Miss State Court, you're not muted. Judge, do you all need a court reporter for the competency calendar?
No, we're good. We're good. We have concluded with the calendar. We've concluded the competency calendar, and the litigation manager has made a note of all the reset dates for the cases that are going to be reset, with the exception of position number 14. Terrell Swinger, that case is null pros, so Mr. Walker will be submitting a null pros order. I see that we have a couple of folks here by the last name of Samir that may be related to position number 13, John Claude Samir. Now, this is an open virtual court proceeding. It's not only live stream, but it's also recorded. So I don't permit any medical, psychological, or confidential information to be divulged during the course of these proceedings. Now, if anybody wants to confer with me with regards to this case, I'm going to do so in a breakout room with prosecutor Ian Walker and Miss Kasha, the social worker. So between Carolyn and Jordan, who would like to go in the breakout room? I'm sorry, Miss Carolyn Samir, your audio is not connected.
Hi, can you hear me?
Okay, Miss Channing Samir.
Yes, I would like to go in the breakout room, and I think Carolyn would as well.
All right.
Is it possible for all three of us to?
No. Who is going to be the best spokesperson? Channing, Jordan, and I'm assuming Adriana Vasquez. Who's going to be the best spokesperson?
I think Channing makes the most sense.
Channing and Carolyn, please.
One person, guys. I'm it's like 1, 2, 3, 4. Carolyn or Channing? Who?
I think it's fine if Carolyn represents in the moment.
Carolyn needs to get her audio connected.
Okay, can you hear me, Judge?
Your audio is very low.
Okay, I can't get this. Okay, how is that? Is that?
It's a little better. I can hear you.
Okay.
Miss Champion, please place Carolyn Samir, Prosecutor Walker, and Miss Kasha and me in a breakout room.
And Mr. Bumati, if you could check the chat, I messaged you.
All right, thank you.
All right, Ms. Samir's audio has broken down. Please place Ms. Channing Samir in the breakout room, please. Ms. Champion, please place Ms. Channing Samir in the breakout room.
I did, Your Honor.
Hey, Mr. Bumadi, just be on the lookout. I'm about to message you right now.
All right, we have concluded with all cases. Ms. Channing Samir will share the information with her family members, and that would conclude the calendar for today. We'll be in recess until we address our expedited calendar at 2 p.m. Thank you, everyone.
Judge,
Yes.
can you please give me on the competency calendar, the recess dates for 5, 6, 7, and 8, please?
Okay, position 1 is 5/19, 2 is 5/19, 3 is June 2nd, 4 is June 2nd, 5 and 6 are May 19, 7, Bonnie Conley is May 19, 8 is June 2nd, 9 is June 2nd, 10 is June 23rd, 11 is further notice for trial. 11 has been released. Number 12 is June 2nd, 13 is June 9th, 14 is Noel Prost, 15 is June 2nd, 16 is June 9th. Good?
Yes.
All right, excellent. All right, Ms. Grace, I'm here. Just email me or call me with regards to the documents to be signed, okay?
Thank you.
Thank you. Thank you, folks. Bye-bye.